गौरी ठीक है, ये नोट कर दिया, ये वीडियो वो छोड़ दे, वो अपने
Jivan sir, I think we can start the session. It's 10 a.m.
Am I audible?
Yes, sir.
Good morning, friends. I'm your friend Jivan Bhosle. I welcome you all on behalf of Bharatiya Bima Karmachari Sena and Mumbai Insurance Institute. We have arranged today lecture on HR Legal. Our today's faculty do not need any introduction. He is Mr. Hanif Sheikh. Sir is an ex-New Indian and ex-vigilance officer. Sir has served for 40 years for New India, and even after his retirement, he is serving our company. Sir is the person behind many changes in vigilance rules and CDA rules. even now, if there is any issue regarding HR legal, all 4 PSUs call sir for the solution. Now, without wasting further time, I request sir to take over and start the session.
Not audible, sir.
Hello. Can you hear me now? Hello.
Yes, sir.
So whatever I have talked earlier, could you listen to it?
No,
No. Okay, then I'm again repeating that. See, I'll be mainly talking about the CDA rules, then the rules connected with departmental inquiry, imposition of penalties, suspension period, and appellate authority, then memorial, then disciplinary authorities and all. Because this is a sort of some complex subject, because you are quite aware of the HR policies, whatever benefits you are getting and all, but you are not familiar with the CDA rules and the rules connected with departmental inquiries. So my thirst will be more on the CDA rules and the departmental inquiries. So now, we come across what is discipline. See, you may be knowing that in all sphere of life we are governed by certain rules and regulations. See, even if you are driving a vehicle on the road, so we drive from the left side of the road. Why? Because the rules of the country say that you need to drive the vehicle from left side. And supposing if you start driving from the right side, that will be traffic violation. In the same way, even we, as an insurance company's employees, we are bound by certain rules and regulations. So every department has got their rules. So now supposing if you deviate from those rules and regulations of the company, if you violate those rules and regulations of the company, if you contravene those rules and regulations of the company, if you are showing disrespect to those rules and regulations of the company, if you are showing utter disregard to these rules and regulations of the company, you are negligent in performing your duties, you are careless in performing your duties, you are not adhering or not observing to the rules and regulations of the company, then it becomes a misconduct. Now you will be surprised that why I have used so many of terminologies, because you will find every time some will say that you have deviated from the rules of the company, some will say that you are violated the rules of the company, some will say there is a contravention of rules and regulations, some will say that you are not shown respect to the rules and regulations of the company, you are disregarded the rules and regulations of the company, you while performing your duties, you are found to be negligent, careless, and you are not adhere to or not observe the rules and regulations of the company. Everything, all this terminology comes to a conclusion that if you resort to this sort of a conduct, that it is nothing but a misconduct. Are you clear about this? Are you clear about this? Okay. Okay. Now see, there is always a question that why CDA rules is applicable to whom? So these rules are applicable to all employees appointed to any post by the company. So except whom officer on deputation from All India Service, Central Service or State Services and casual employee. Now you will be surprised that since all the employees are governed under CDA rules, then why not the officers who are on deputation from All India Service, Central Service or State Service? Is it that supposing if these employees, if these people who are on deputation from other services, if they commit any misconduct, they will go scot free or no action will be taken against them? No, the action will be taken against them because they have come from some other companies. So their company CDA rules will be applicable to them and they will be tried under that CDA rules. And same way, it is not applicable to casual employees. You know, casual employee itself suggests that they are not our permanent employee. They have been appointed to carry out a specific job. The moment that specific job is over, so there is no more relation of that casual employee with the organization. Now, supposing if one day a sweeper doesn't come to the office and the office needs to be cleaned, then by that time either divisional manager or branch manager or senior DM, what he will do, he will call someone to clean the office and he will be paid some amount, whatever has been agreed. The moment that amount has been paid and he has completed his task, so he will know he will not have any relation with the organization. Therefore, the CDA rules are not applicable to him as well. Now see, we come across that yes, this person has committed a misconduct. Okay, so misconduct, if he has committed a misconduct, then what is the next course of action? Now, supposing even if in your housemaid, if your housemaid, if he or she makes some mistake, now if he breaks a glass or if he throws his utensils and all, so that is sort of a misconduct only. So that time what we'll do, we'll immediately take some action that we'll ask him not to carry out the work and he'll be asked to leave the house immediately. That means you are taking some sort of an action. Same way, if some people have committed a misconduct and there is a financial loss to the company or otherwise also, if it is not coming within the frame rules of the CDA rules, then definitely uh, if someone has committed a misconduct, then definitely some action has to be taken. So therefore, under Rule 23 of our CDA rules, there are two penalties which are specified in those rules. One is minor penalty and the other one is major penalty. So minor penalties, that is rule number 23. The first penalty is censure. Censure is nothing but a warning, that is a recorded warning. See, unless and until a charge sheet has been issued to any employee, he cannot be awarded a penalty of censure. So for imposing a penalty of censure, it is a must for the management to issue a charge sheet, either for minor penalty or major penalty. So charge sheet a must. So what is the difference between censure and a any sort of a warning? So warning can be given supposing if you have committed a mistake. So based on the gravity of the misconduct, management can decide to issue a warning letter. That will not be a penalty. But supposing if you have committed a misconduct and the gravity of it is serious and management wants to management will first issue a charge sheet for you, and depending upon your explanation, they will issue a censure. So this is a recorded warning letter. Okay. Then withholding of one or more increments for a specified period. See, we all get annual increment at us on a specific month. So supposing if a person has committed a misconduct and according to the management that is not of that serious in nature, then they can think of with imposing a penalty of withholding of one or more increment for a specified period. Now, supposing we are now in the year 2022, my increment is due in the year 2023, and in between, if I committed a misconduct for which I have been issued a charge sheet, then management can impose a penalty of withholding of my next increment. That is in 2023, I will not get the increment, but that will be for a specified period, and that specified period cannot be more than 3 years. So supposing if your increment for 2022-23 has been withheld for a period of 3 years, so you will not get increment for 2023, 24 and 25. So these 3 years are over. The moment you go to 2026, so you will get your increment. That increment, whatever has been withheld now, that will be getting restored. Okay. Then recovery from pay or such other allowances for causing pecuniary loss to the company. Now, because of your act, some financial loss has been caused to the company. So after issue of charge sheet, if the charge is proved or if the management is of opinion that he was an erring official, because of him, the
Excuse me, sir.
yeah.
सर पॉइंट बी में जैसे अगर 2026 तक सब विदहोल्ड हुआ है, अगर 26 में लगेगा तो प्रीवियस तीनों लग जाएंगे कि
नहीं वही अच्छा, very good question. See, in 2023 he will not get his increment. Now assuming that his basic is 100 rupees and 10 rupees is an increment. So from in 2023 his increment should have been 10 rupees, so it would have been 110 rupees, but that will be kept at 100 rupees only. When he goes to 24, so he will get one increment, so it will be 110. Whereas if no penalty was there, it would have been 120. Now next year he will go again, so it will be 120. If no penalty was there, it would have been 130. Now next year, when all three years will be completed, so that time his increment will be 130 plus 10. So that one increment will be restored, so it will be 140 years, 40. So that means for 3 years he was not getting one increment. Am I clear now? Is it clear to you?
Yes, sir.
Clear now? Okay. Now recovery from a pay or other allowances for causing pecuniary loss to the company, that I have already explained it to you. Now reduction to a lower basic salary temporary for a period not exceeding 3 years. Now see, we were saying the withholding of increment. Now reduction means immediate reduction. Now from 100 he will be brought back, he will be brought to 90 rupees. Okay. Then that will be for a period of 3 years. So next year he will get his increment. Second year also he will get increment. From 90 he will go to 100, 100 to 110, 110 to 120. And the moment he goes to 130, so that 10 rupees will be again restored. Understood? Hello?
Yes, sir.
Yes, sir.
Sir, one doubt is there.
Pardon?
Sir, can we give him 140 directly, or we will give him allowance also for the back years?
No, see, only one increment will be restored to him. So supposing if we give all the benefits, then where the question of imposing any penalty will arise.
Right, sir.
So he will be placed, he will be given one increment only after the period of his punishment is over, that is 3 years. Now supposing if it is for 1 year, then after 1 year. If it is for 2 years, then 2 years. 3 years, 3 years. So this sort of a penalty cannot be for a period exceeding 3 years. You cannot say, I mean, we are reducing his basic by one stage for a period of 3 years. For a period of 4 years, or we are withholding his one or more increment for a period of more than 3 years. Now see, to understand, normally there will be question in the examination. They identify which of the following is minor or major penalty. So the best way to understand what is minor penalty and what is major penalty. Minor penalty will always have a temporary effect. It will have a temporary effect. And major penalty, it will be a permanent effect. So now we go to major penalty. See, in minor penalty, we were saying the withholding of one or more increment temporarily for a specified period. Now this is withholding of one or more increment permanently. That means now 100, if he is on 100 rupees, So next year he will not get his increment, it will be 100 rupees. Next year he will get his annual grade increment, that will be 110. Next year also it will be 120. So always he will be one step behind. Now, supposing, assuming one of your colleague has been imposed with this sort of a penalty, and yours and his basic is same, so you will always be one step ahead of him till he gets promotion or till he reaches his state of stagnation. Okay. Then reduction to a lower service. So what I told you about major penalty, it will be having a permanent effect only. Now reduction to a lower service or a post or a lower time scale or to a lower stage. So now reduction to a lower service. That means supposing if a person is promoted as A and he has committed any misconduct which is serious and management can reduce him to the lower service. That is from assistant manager he can be brought to AO's cadre also. That is post also. Service or post or lower time scale. Lower time scale means same. Now from assistant manager he will be brought to AO's time scale. So there will be quite a difference in the salary which he will be drawing or to a lower stage. Now supposing if a person is drawing a basic salary of 100 rupees, so his basic can be reduced to by any stage, even to a lowest in the basic. Now supposing if the basic starts at 10 rupees and now he has reached the stage of 100 rupees basic, so his basic can be reduced to 90, 80, 70, 60, 50, 40, 30, 20 or 10 also. Okay, so that will have a permanent effect. Only after completion of 1 year, he will start getting one increment. So supposing if he has put in 10 years of service and during the period of 10 years of service, from rupees 10 to he has gone up to 100 rupees. But after 10 years, his basic has been reduced to 10. So again, he will require 10 years to reach up to the basic salary of 100 rupees. So this is a permanent clause. Now, compulsory retirement, removal from the services and dismissal is one and the same penalty. Now, so depending upon the gravity of the misconduct, if management feels that these services are no more required because he is not a person of highest integrity, so it is better we remove him from the services of the organization. So he will be either asked to go for compulsory retirement, or we will remove him from the services, or we will dismiss him from the services of the organization. All these carry same meaning. Any question
Hello?
on penalties?
Hello,
Yeah.
sir. What is the difference between removal and dismissal?
See, removal. See, when you are removed from the services of the company, you don't carry that stigma. You can get a service somewhere else also. But when a person is dismissed, so he carries a stigma, and the chances of his getting service is very remote. That is the only difference. Because in all this GHI, the people are not going to remain in the organization. Okay.
So one thing more, in case of major penalty, like reducing the increments by 2 stages permanently in the month of like November, will he get his annual increment which is
He
due
will
in
get his
April?
annual increment whenever it is due. Now,
Right.
suppose assuming that you are reducing his basic by one stage in the month of November, and he is getting his annual increment is due in the month of December. So from 100 you have reduced him to 90. But when December comes, so he will be getting one increment and he will be again 10. Now you will be feeling that how come then where is the pinch of the penalty? But you should understand that when he was brought down to 90 rupees, then he is coming to 100 rupees. Had that penalty not been imposed, so instead of 100, he would have been 110 rupees. Understood? Hello?
Right, sir.
Yeah.
Right, sir. Okay. Thank you.
Hello.
Yeah.
So whether these CDA rules will be applicable to CMD also?
Yes, sir, definitely.
Yeah. Thank you, sir.
You are calling from where? Hello?
Hello.
The person who had asked this question, whether these rules are applicable to CMD also.
So I am under Ludhiana.
Ludhiana? Okay.
Yeah.
Yeah. See, I will tell you one thing. I mean, I need not name the person. You must be knowing that one of our CMD was also charge sheeted earlier. So that was under CD rules only. Okay.
Thank you.
Yeah.
Sir, I have one doubt.
Yeah.
If there is a reduction in one increment,
Yeah.
will the person lose his seniority? And
So he
will
will
he
not
be?
lose the seniority. Seniority, I mean, there is no question of losing the seniority because he will be in the same seniority list which he was, where he has been placed.
Okay, he'll be with the same batch.
Yeah, yeah, he will be in the same batch.
Okay, thank you, sir.
Excuse me, sir.
Yeah.
So in case of compulsory retirement, will he get all the retirement benefits?
See, that depends. Now, provident fund, so nobody can attach by way of any degree from either tribunal, court. Okay, so provident fund is his own contribution, so that definitely he is going to get it. And supposing if he has opted for this CPF, contributory provident fund, so the part of the provident fund to which the company has subscribed, that amount will not be given to you. Now, supposing if I have contributed 10 lakhs and there is a contribution of 10 lakhs from the company, so supposing if he has been removed or dismissed or compulsory retired from the services of the organization, then he will not get the amount which has been contributed by the company, that is 10 lakhs rupees he will not get, but 10 lakhs rupees of his own contribution that cannot be touched by anyone. Okay. Hello. Hello.
Right, sir. Okay.
Okay. Now see, just because you want to penalize someone, that's not possible. Because there is some.
So one thing more, so please, sorry. One thing more, effects of these major penalties or minor penalties on promotion.
Yeah, that I will take. That is a rigor effect that will come in the next
Right.
this thing.
Okay,
Definitely, but you can write down and keep it with you. Supposing if I miss out that, then definitely you can ask.
Okay, sir.
Yeah. Now see, I told you, Kami, because we are working as a public servant. So supposing tomorrow, if you are not getting along with your divisional manager, branch manager, regional manager, DGM, GM, that doesn't mean that he will just try to harass you by issuing a charge sheet. So there is a procedure for imposing minor penalty and major penalty also. See, supposing if somebody has committed a misconduct and that has been proved in the sense, I mean, based on the documentary evidence and the oral evidence which has been collected by the vigilance officer during his investigation, and management feels that this matter is not that serious, but still it's a lapses on the part of the erring official, so they want to issue him a charge sheet for minor penalty. So they will issue a charge sheet wherein the imputation of misconduct will be conveyed to him by way of a charge sheet. Then he will be asked to submit his written statement of defense. The written statement of defense is nothing but you have been given an opportunity to explain your side when a charge sheet has been issued to you. Now, depending upon your statement of defense, if management feels that he is not at fault or if he is at fault, then they will take a decision to impose the penalty what has been specified under Rule 23 A, B, C, D. What we have learned, that is censure, then recovery, then either withholding of increment or reduction in basic salary. Okay. So in minor penalty, you don't get a chance to explain your side by having an, you don't get a chance of being heard before an inquiry officer, because there is no need of appointing an inquiry officer. Okay. Now procedure for imposing major penalty. Okay. Procedure for imposing major penalty. Now see, the vigilance officer comes, he investigates the matter, he submits his report, and he gives his conclusions also that whether that employee who has committed a misconduct is at fault, whether it has been done with a malified intention or malified intention and ulterior motive, or it was a genuine mistake on his part. So depending upon that, the disciplinary authority will go through his report, I mean vigilance officer's report, then circumstances going against the employee and in his favor, and they will decide that yes, this person has committed a misconduct which is grave in nature, and therefore they will decide to conduct a department to initiate disciplinary action under major penalty proceedings. So for that, they will first issue a major penalty charge sheet, and he will be asked to submit his written statement of defense. Once that written statement of defense is received, the disciplinary authority or management will go through it, and they will decide to institute a departmental inquiry. Departmental inquiry is nothing but see, the word itself says it is departmental inquiry. That means it's an in-house inquiry. So naturally, the appointment of an inquiry officer and presenting officer will be done from the office employees only. The exception is inquiry officer. Now, even a retired employee can be appointed as an inquiry officer. So this department inquiry is nothing but it's sort of a non-judiciary proceedings. Likewise, what we see in court, now court is consisting of the judge, then the public prosecutor, and the defending advocate. The same way here, the judge will be inquiry officer, the prosecution advocate will be presenting officer, and employee and his defense assistant, that is an employee with the co-employee, can be a defense assistant, and he can assist the charge sheeted employee in defending himself. Then I told you the officer of the company, public servant or retired officer can be appointed as inquiry officer. So it is only officers. We can say public servant can be even an assistant, so assistant cannot be appointed as an inquiry officer. Only officers have to be appointed. Any question on this? Any question? Should I go ahead? Okay. Now, there are various issues. Any imposition of penalty, important point. Whether major penalty can be imposed without oral inquiry. See, what I told you, in minor penalty, only charge sheet is issued, and based on your explanation, the management will decide to impose a penalty or take a suitable decision. But in major penalty, without conducting an oral inquiry, if any penalty is imposed, then it will be vitiation of principle of natural justice. Because a major penalty charge sheet has been issued, and you will get an opportunity to present your case before an independently appointed inquiry officer. So therefore, major penalty cannot be imposed without oral inquiry. Now, whether major penalty can be imposed for major penalty charge sheet, whether minor penalty can be imposed for major penalty charge sheet. The answer is yes. I'll give you the explanation. Now, supposing if claim has been settled by the DCC members, and you find that the person who has processed the claim has brought out some discrepancies in the claim, and in spite of that, the officer, the recommending officer and sanctioning officer, or the chairman and the DCC members, they were of the opinion that this query raised by this employee or the officer or the class 3 employee is not proper, and in spite of that, if they have settled the claim, so in that case, management can think of not imposing major penalty, but a minor penalty way of censure can be imposed on the charge sheeted employee who has just prepared the note and who has highlighted the discrepancies also. But major, if you are issued whether major penalty can be imposed for minor penalty. Now we were saying if major penalty is issued, minor penalty can be imposed on that. But supposing if a minor penalty charge sheet has been issued, then penalties which is prescribed under Rule 23A CD only can be imposed. No major penalty can be imposed for a charge sheet which has been issued for minor penalty, because the basic principle is that for minor penalty we don't take oral inquiry. It is just based on the written submission made by the charge sheeted employee. So therefore, for minor penalty, major penalty cannot be imposed. Any question? Any question, or you are clear? At least someone tells.
Excuse me, sir.
Yeah.
So if management finds that the minor penalty is not sufficient, then what they do?
No, minor penalty, see, charge sheet has been issued for minor penalty. So that means the application of mine by the disciplinary authority was there right before issuance of the charge sheet. Once he had decided to issue a charge sheet for minor penalty, definitely the penalty which is prescribed under minor penalty rules 23 A, B, C, D only has to be imposed. Understood?
Sir, if they find after inquiry
Huh.
that something major is involved, then what should they do?
No, inquiry means that is a major penalty only. No, see, when domestic inquiry has been instituted, that means the charge sheet was for major penalty. And subsequently, if it is found that this person is guilty, then definitely major penalty under section 23E onwards can be imposed on him. Including dismissal, if the gravity of the misconduct is such that the that management decide to impose a penalty of dismissal, that can be imposed on.
Thank you. Thank you.
You
Sir.
understood, na? Yeah.
Sir, in previous slide, you said that inquiry officer must be an officer. Okay.
Must be.
But what about must be an officer?
Yeah.
What about defense assistant? Whether defense assistant can be an assistant or it must be
Defense
officer?
assistant only has to be an employee of the organization, not an retired employee, not an advocate.
Okay. लेकिन ऑफिसर ही होना चाहिए कि असिस्टेंट भी हो सकता है?
Assistant भी हो सकता है, even sub staff क्या है, आप अगर supposing if you feel that the PTS is in a better position to defend you, even you can hire him as your defense assistant.
Okay, thank you, sir.
For that matter, it's not an exaggeration. Supposing if even GM and CMD is ready to help some employee in defending his case, he can be also a defense assistant. Only thing is that he should be a present employee of the organization and he cannot be an employee from other insurance companies also. He should be employee of the organization.
So is there time limit for filing written statement or like
15 days. See, the charge, when the charge sheet is issued to you, you are supposed to submit your written statement of defense within 15 days of receipt of charge sheet. Any question? Okay, next. Now see, we have said, we have understood what is misconduct. Then if you commit a misconduct, then you are liable to be tried under minor penalty proceedings or major penalty. So what are the minor penalties and major penalties that I have explained it to you? Minor penalty will always have a temporary effect and major penalty will have a long lasting effect. Now there are various proceedings where normally this sort of a question is asked. This rule number 29, that is common proceedings. Now common proceedings means what? Supposing if a claim has been settled by a DCC and all the employees have been found guilty, then a charge sheet will be issued. Then instead of calling witnesses at a different date, instead of calling witnesses one by one in case of one employee or each employee, it is always better to call one witness who will be deposing his evidence before all the charge sheeted employees. So that is called common proceedings. So that time this witness will come, he will give his oral evidence that will be recorded, and based on his oral evidence, all the three employees or all the charge sheeted employees will get an opportunity to cross-examine. So that is called common proceedings. So that saves a lot of time also. Now there is rule number 30, that is special procedure. What I have told you, whether we can impose a major penalty of dismissal without issuing a charge sheet. Can we do it? Somebody answer. Please, someone answer. I expect
No,
an
sir.
answer.
No, sir.
It cannot be, but there is some special procedure. And what is that procedure? Now, supposing if someone has been convicted by the court or undergoing a rigorous imprisonment of 3 years, 4 years, 1 year, 6 months, whatever it is, on a criminal charge which is involving moral turpitude, So supposing if someone has been caught for stealing, say stealing or robbery, and he has been convicted, whether you would like such employee to be on the roll of the organization? No. So in the interest of the security of the organization, it's not expedient to hold the inquiry, domestic inquiry, because this he has been already convicted by the court on criminal grounds. So such employee should not be retained in the organization, and therefore under by invoking the provisions of rule number 30, they will be straightway removed, dismissed from the organization of the company. There is no need to conduct an inquiry. You understood this? Have you understood this?
Right, sir.
Yes, sir.
Yeah. Then this is one. If a person has been convicted on criminal charges. The other one is abandonment of services. So do you know what is abandonment of services? Now I'll give you an example.
The employee does not.
Some of you must be direct recruits also. Some of you must be promoted from class 3 also. You must have seen that some of the employees, they join the duties. They join the organization. Subsequently, they don't come to office. They don't inform the office. They don't submit the application. Neither their whereabouts are known. They don't have sufficient due to their balance and all. And if that period of absenteeism exceeds more than 90 days, for which you are no intimation from the employee, he has not submitted any application, he doesn't have any leave to his credit, his whereabouts are not known. So such employees can be dismissed or removed from the organization without holding an inquiry or without issuing a charge sheet. So you must have understood now what is rule number 30, that is special procedure. One is, well, there is no need of conducting an inquiry if a person has been found guilty by the criminal code on the charges of criminal offense involving moral turpitude, or a person who is remaining absent from office for 90 days without intimation, without approval, without submitting application, without sufficient due to his credit. Such employees can be straightway dismissed from the services of the organization.
Sir, 90 days in a calendar year.
No, 90 days continuous.
Continuous. Okay.
Yeah. Now, supposing if a person is not there for 10 days and he joins on 11th day, you cannot do. You cannot, invoke the provisions of this rule, because after 10 days he will give some excuse and all that will be regularized and all. That is there. But supposing for 90 days, neither he is coming to office, and even after you send him a reminder or send him a letter and he is not responding, then in such case, this rule can be applicable for initiating the action against him by way of a removal from the service.
But sir, if he has intimated on mail and requested for loss of pay.
Yes, so, that can, supposing if he has informed, then there is no problem. Okay. If he has informed, but if he has not informed, you don't know his whereabouts, and in spite of you have written to him various letters, he is not responding. That means what? He is no more interested in continuing with the services of the organization. Therefore, we declare him to have abandoned his post or service, and we terminate him or remove him from the services of the organization. Any question?
Fine.
Now we come to ex-parte proceeding. That word itself suggests ex-parte proceedings means what? See, there are three parties in the inquiry proceeding. One is inquiry officer, other one is presenting officer, and third one is the erring official or the delinquent employee or the charge sheeted employee. Normally, you will find that the inquiry is delayed because the charge sheeted employee is not coming forward. Even if you issue him a charge sheet, if you give him a summons that we have decided to have a preliminary hearing or regular hearing on such and such date, he under one or the he will not he will not come forward and attend the inquiry. So in that case, what this ex-parte proceeding has to take place. So what is ex-parte proceeding? If the employee is not coming forward, then the inquiry officer has to give him 3 chances. On 3 occasions, supposing if he doesn't come, and if he doesn't give any substantial reason for his remaining absent from the inquiry, then the inquiry officer can hold this inquiry proceeding ex parte. So ex parte may what will happen, the charge sheeted employee will not be there, inquiry officer will be there, presenting officer will be there. And this can be held only after giving 3 opportunities. On the 4th day, on 4th occasion, if he doesn't come, then the inquiry officer has got a prerogative to start the inquiry proceeding, start ex parte proceeding. So in ex parte proceeding, what will happen? Management, that is presenting officer, will try to substantiate the charges by adducing oral and documentary evidence that will be recorded by way of a minutes of the daily proceedings. Now, at the end of the day, that will be signed by inquiry officer and presenting officer only, because the charge sheeted employee is not there. His name will be written there, and it will be written against his name, he is absent. But the rules of the ex parte proceeding says that on day-to-day basis, whatever has been transpired and whatever has been recorded by way of minutes of that particular day has to be sent to his residential address, last known residential address, by registered AD. That means he is in the know that what is going on. What stage the inquiry is going on. So for that matter, even the minutes can be sent by a registered AD or speed post or through ordinary post also. But we need to keep some record with us. Now, it may happen, or there may be a query in your mind that this person has refused to accept the registered AD letter or the letter sent by speed post. So in that case, those registered AD letters or the letter sent through speed post will be returned back to the inquiry officer. So in that case, the inquiry officer is required to preserve that envelopes in the same position. He doesn't have to tear it out or open it out. It will be kept like that only. And tomorrow, supposing if that employee goes in the court, that natural justice has been vitiated in his case, that time we can very well show those documents, and that will be opened by the judge himself, that we had already shared the minutes of the meeting to him, but he refused to accept it. So in the same way, this ex parte proceeding will continue. So once this is over, all the witnesses on behalf of the management is over, you will send him one more someone that if he requires, he can be present, and he can present his defense witnesses and defense documents also. So if he doesn't come, then you have to record like that. Then finally, you will be you will be asking the presenting officer to submit his written brief, and that copy of the written brief will be again sent to the charge sheeted employee, wherein he get an opportunity to rebut against the findings of the PO or the averments made by the PO. And supposing if he doesn't give that within a time limit, then inquiry officer has got a prerogative to submit his inquiry report to disciplinary authority. Is there any question in this ex parte proceedings? You may be having some doubt.
Sir, can you please explain rule number 29 once again?
Pardon?
Rule number 29. Sir, actually, I missed it.
Rule number 29.
Yes, sir.
That is common proceedings. Now, charge sheet has been issued to 3-4 employees for arising out of one incident only. So everybody's role is different. But the witness who will be coming forward to depose against them, they will be allowed to sit together only. All the charge sheeted employee, because that witness will be giving evidence against them. So whatever evidence they give, that witness gives, so these people will get an opportunity to cross-examine him one by one. So instead of calling that witness for one charge sheeted employee, then again for second, then again for third, so he will be called only once, and all the three charge sheeted employees will get an opportunity to cross-examine. That is called common proceeding. Okay.
Okay, sir.
Now, hello, sir. Hello.
Yeah.
Sir, whether question can be asked from the procedure of inquiry?
Procedure of
Inquiry
inquiry.
proceeding. Yeah.
No. Procedure. I am explaining you the procedure, na.
Okay.
I am
Okay, sir.
explaining. Now, ex-parte proceeding, you must be having one query in your mind, or you
Okay.
don't have any query.
No query. Questions may be asked in exams.
Pardon?
For procedure of inquiry, जो इतना लंबा प्रोसीजर है उसमें से कोई क्वेश्चन आस्क हो सकता है भी?
आता है ना.
Okay.
See, now ex-parte proceeding mein, there is one more query, I mean, which I am asking now. Now, supposing if the charge-sheeted employee, he doesn't attend three hearings, and on fourth hearings he comes and he presents himself before the inquiry officer, whether he'll be allowed to participate in that day's proceedings.
Yes. He may be allowed?
Yeah, he should be allowed. Yes, correct. He should be allowed.
Okay,
now,
sir.
concurrent inquiry proceedings. Now, sometimes what happens, you must have come across certain cases that some person has committed a misconduct, and the department inquiry has been initiated against him, and simultaneously the CBI also comes into picture, or a criminal proceeding has been also initiated against him, or it has been contemplated against him. So, inquiry under CDA rules and inquiry under criminal procedure will be held. So, inquiry under CDA rules will be conducted by the office, and for criminal offense it will be conducted by the court. So, even if the charge is same, it is not like that. I mean, only one inquiry will be there. Inquiry, domestic inquiry will be conducted under our CDA rules, and court will look into the charges framed against him under criminal proceedings rules. Then what happens now? In supposing if the court exonerates him or court acquits him with honor, and in our inquiry has been found guilty, so the decision of the court will not prevail on our decision. Simultaneously, now court has found him guilty, but in a departmental inquiry, no charge could be proved against him. So the outcome or the outcome of the criminal proceeding will not have bearing on our departmental inquiry, and vice versa. Understood? Understood or not? Any query on this?
Sir, there was a special procedure in one of the previous slides. Correct. Where if the court has convicted,
yes, yeah,
we can directly take action in the CDA rules.
Correct.
So will it not apply in this condition also, where the criminal
I'm not saying the here the management has decided to initiate action under CDA rule. Simultaneously, the case has been filed against him in the court, or with CBI or ACB, whatever it is, and they have also may frame a charge against them under which the inquiry or the court proceeding is going on. So decision is not there at the moment. What you are saying now, what I was talking to you about rule number 30 is that if a person has been convicted, he has been convicted, so there is no need of conducting a departmental inquiry. Now here see, what I was referring to was that if a person has been caught for committing any misconduct which is involving criminal misconduct, it's not necessary that it is related to settlement of the claim or misappropriation of the premium at all. That may be a act which is which has done outside the office premises, and which is not coming within the purview of the CDA rules. Like supposing he was in the state of intoxication and he murdered someone. So for that we cannot have a departmental inquiry, because that is necessarily a criminal offense only. So based on the criminal offense finding of the court, if he has been convicted, so there is no need of conducting any inquiry further by the department or the organization. Therefore, we impose a penalty of dismissal on him. What I am talking about here is a person, supposing if a misappropriation has taken place, so management will definitely initiate action under CDA rules for major penalty proceeding. And simultaneously, if this matter is brought before the police department or CBI, so they will also file a charge sheet. So still the decision is not there. The decision of the court is not known. What I am saying now, supposing if the management has taken a decision that will exonerate him, and the court is taken a decision to impose a penalty on him. So court's decision will not have a bearing on our decision, and our decision will not have a bearing on the court decision.
Sir, one more question. Yes, sir.
Yeah.
So one more question. Can departmental proceedings be initiated on a penal offense? For a criminal offense, sir.
No, we cannot. Nah, see who has investigated that matter? Who are the witnesses? They are all outsiders.
Okay, sir.
Okay. So you understood?
Yes, sir.
Okay. Now there is one more question which comes, that is outside employment under rule that specifically has been given under rule 6 and 7 of CDA rules. Now, employee not to seek outside employment without previous sanction of the competent authority. What do you mean by this? They are saying, is it so that you can seek outside employment, but with previous sanction of the competent authority? That you need to have a prior approval of the competent authority before you indulge yourself into a part-time job. Am I right? Hello?
Yes, sir.
Yes, sir.
So see here what happens, I will tell you. Now, why the previous sanction of the competent authority is required? Because then management will come to know that this person after office hour or because of office hour is working with some other organization for which he is getting some sort of honorarium, remuneration, whatever it is. So in that case, management will give him approval subject to his depositing whatever remuneration, honorarium or fees what he is receiving by way of such outside part-time employee, a part-time work. And then management will decide how much has to be apportioned between the employee and the organization. Now, supposing if he is getting a 10,000 rupees by way of an honorarium or a fees or a remuneration, so all 10,000 rupees he will be required to deposit with the office. And management will decide how much has to be apportioned, whether management will keep 8,000 rupees with them and 2,000 to him. So normally people don't like this idea, therefore they don't inform the office. They don't inform the office. And subsequently, if someone is caught and there are proofs available, then management will not let him off like that only. So he will be, subject to some sort of a disciplinary action. So even if it is written that the previous sanction of the competent authority is a must before you seek outside employment or part-time employment, people don't come forward to seek approval, because they know that though they will be earning 10,000 rupees, they don't know how much will be paid to them. And it is but natural that if a person wants to earn 10,000 rupees, out of that he is required to share even 50% of it, he will not like it. So they don't inform, and subsequently what happens, they land in trouble if someone makes a complaint, and if there are documentary evidence as well as oral evidence against him, then management will not let him go like that, only action will be taken against him. Any question on this?
Sir,
question?
Sir, does this provision is applied to application to full-time employment outside? That is, somebody is applying for any examination or something like that?
Full-time job outside?
Sir, there is a
here
provision.
the question is an employee of the organization. If he wants to go for full-time job somewhere else, he needs to resign from the organization and join there.
Sir, there are competitive exams for recruitment outside.
Yeah.
For that, our personnel department asked for a this thing intimation to the department in advance.
Yeah.
Does that provision comes under this rule only?
No, no, no. See, that is another. See, if you want to pursue higher studies, if you are preparing yourself for some examination, so you need to take the permission of the office. Now, I am an employee of the organization. See, I am a graduate, but I want to pursue my post graduation, so I need to take the permission from the office.
Okay.
Yeah. Now, due rules. Now, due cannot be asked as a matter of right. Is it right? Is it right? Due cannot
Yes,
be
sir.
asked as a matter of
Yes,
right.
sir.
Yes, right.
Yes, sir.
Yeah. Why?
Hello, sir, I
Yes.
have one doubt.
Yeah.
Sir, you said you have to take permission for higher education, no, from the management.
Yeah.
So in that case, if you want to do higher education, we can resign the job immediately, or we have to give prior intimation to the company. Prior
See,
notice.
see, I don't know, I mean, which cadre you are and all, whether you are a permanent employee on. Supposing if you are a permanent employee and you want
Okay.
to pursue higher studies, so there is a provision in the organization that you can take a study leave also.
Okay, okay.
You can take study leave, and supposing if you doesn't want to take, if you are not interested in taking any leave and you want to join the full-fledged college or school, whatever it is, then you need to resign. And in that case, if you are a permanent employee of the organization, you can give one prior notice of 3 months, or in lieu of that, you have to pay 3 months salary and get yourself leave immediately.
Excuse me, sir.
Yeah.
And this notice of 3 months is also applicable for class 3-4 employees.
Yes, yes, it is for all.
Whether this is 3 months or 1 month
3
notice
months,
for
3
at least 10%.
3 months.
3 months.
Yeah.
3 months for all class of employees.
All class of employees.
Okay, thank you, sir.
Now, prior permission is must except in case of 1 day CL. See, whenever you are proceeding on leave, PL, so it has to be necessarily sanctioned in advance only. And casual leave also. Supposing if you are proceeding for 2 days schedule leave, 3 days schedule leave, you need to inform the office, obtain the approval, and then only proceed. Only exception is that if you are on CL for a day, there is no need to inform the office immediately. It's not like that. I mean, you should not inform. It's not necessary. If you inform, it is well and good. But if you don't inform, then also management not going to ask you. Only thing when you will be submitting your application nowadays you will be required to submit online only. That time only you have to give the reason. That's all. And normally this sort of unpleasant situation never comes here that your immediate boss will disallow that particular 1 day schedule. Then late attendance or early leaving for more than 3 occasions lead to forfeiture of half days CL. See, our office timing is 10 to 5:30, 5:45, whatever it is. Normally what happens in all the offices, because I have also worked in different offices, I have seen that the departmental in charge or the branch in charge, divisional officer, divisional in charge, he marks the employees late only after if they come late after 10:30. So it has become our regular feature that our office hour is 10:30 onwards. But supposing if a person is not attending office before 10:30 and always attends after 10:30, and if such occasions are more than 3 days, it will be amounting to forfeiture of 1 day CL, half day CL. From his CL account, half day CL will be debited. Either
Sir.
for early, yeah.
Sir, 3 occasions within a calendar month or
In a
any
month,
time?
in a month, in a month. So, I mean, everybody has got that privilege of either attending late or going early on 24 occasions. That is per month, two times you can take that advantage. Anyway, then can't leave headquarters without prior permission. Now, what is headquarters? What is headquarters?
Place of
Place of
posting.
posting.
Your place of posting. Now, supposing if you are posted to a place and say you are posted in Ludhiana.
Sir,
yes.
Sir, headquarter is municipal limit of the place of the posting.
Municipal limits of the posting. See, there are, there are twin cities like us in Pune and Chinchwad. So our distance is hardly 10-15 kilometers. Same way in Hyderabad. And there may be other places also. Headquarter means the place where you have been posted. And thing is that supposing if you are living away from your headquarter. Now likewise, when I was posted to Mumbai in head office, I belong to Pune. So all Saturdays, Sundays, what I will do there, because this is a commutable distance of 3 hours only, we used to come down on Saturday and Sunday. But our office says that though your hometown is Pune, but your headquarters is Mumbai. So whenever you are leaving your headquarters on a holidays or on your leave, you need to inform the office. Now you will say what should be the reason? See, we are the employees of the organization. As per the office knowledge, your headquarters is at Mumbai, so you should have been at Mumbai only on Saturday, Sunday. Now, supposing something goes on Saturday and Sunday with you, so management or the office will not be in a position to know about your whereabouts. Therefore, it is a must that whenever you are leaving headquarters, so you need to inform the office. This is what is the rule of it. Huh? Yes.
सर किसी का माइक अनम्यूट है, डिस्टरबेंस हो रहा है.
अच्छा, किसका माइक अनम्यूट है, जरा उसको म्यूट कर देना भाई. Now, competent authorities. What is competent authorities? That word itself suggests that he is competent to do something. So whenever a charge sheet has been issued, whenever a penalty has been imposed, whenever an appeal has to be considered, whenever you prepare an memorial, so there are designated person who can take the decision in this matter. So for that, there is one schedule A at the behind of your at the last page of your CD rule. You can go through it. I will also explain it to you. So here they have given, against which cadre, who will be the disciplinary authority, who will be the appellate authority, and who will be the official before whom you can prepare your memorial. Okay. So now here you need to bear in mind that supposing if a penalty of either dismissal, termination, or removal is to be imposed, you need to confirm that the person who has issued the charge sheet is in the same cadre who had appointed that person earlier. See, the person should not be the same, but the cadre should be the same. Now, sometime what happens, I tell you, a charge sheet has to be imposed, charge sheet has to be issued to a assistant. And finally, it is decided, and the charge sheet has been issued under the signature of, say, chief manager. And the decision has been taken to dismiss him from the services of the company. But on perusal of his personal record, it is observed or found that this person's appointment as substaff was signed by, appointment letter as substaff was signed by DGM. So in that case, the chief manager, though he is competent to impose this penalty, will not be allowed to pass that order. It will be placed before the disciplinary authority who is in the cadre of DGM, and he will be only signing that order of dismissal, termination, or removal. So please note that the penalty of dismissal, termination, or removal can be imposed by appointing authority only. Okay, any question on this?
No, sir.
No, okay. Now see, once the penalty has been imposed, now in हम लोग जो कोर्ट में जो देखते हैं, in court we have got a session court, then we have got high court, and then we have got Supreme Court. Then a person gets 3 chances to defend himself. First is in lower court, that is we say हमारे इधर disciplinary authority है. Then we go to high court, supposing if we want to prefer an appeal. So here it will be appellate authority. And third one, we go to Supreme Court. So here it will be memorial. So now a penalty has been imposed on any employee or employee. So definitely he will be aggrieved by the decision of the disciplinary authority. He will say, "Arey, mujhe zabardasti inhone penalty diya." Then in that case, what course of action is available to him? So he can prefer an appeal before the appellate authority under rule number 31. And he's get an opportunity to prefer an appeal. But he has to prefer this appeal within 3 months of the date of receipt of his order. Now, supposing a penalty has been imposed on any employee, say on 1st of January. So then 1st of February, 1st of March, and 1st of April, 3 months will be over. So he needs to prefer his appeal within 3 months or 90 days. But supposing if the order is of 1st of January, but he has received on 15th of January. So the 3 months will be counted from the date of receipt of the order. Okay. Then he will prefer his order, then it will go before the appellate authority. Then what could be the decision? Likewise in court, what will happen? And whatever penalty has been given to him, it will be modified on a lower side or on a higher side. Or he may be exonerated also, or his appeal will be totally rejected. So appeal has to be preferred within 30 days, 90 days of receipt of the order. And what will be the further action by the appellate authority? The penalty can be reduced or enhanced, or he can be even exonerated, or the appeal can be totally rejected also. Now his appeal, he is not satisfied with the appeal. Then the other course of action available to him is to prefer an memorial. So memorial will be preferred before the memorial authority, and that will be under rule 40. So when your appeal has been dismissed or rejected or modified and you are still aggrieved by the decision of the appellate authority, so you need to file your memorial within 6 months from the date of receipt of the order. Likewise, I said, supposing it is 1st of January, so after 6 months, that is on 1st of July, before 1st of July, you have to file. But if it is received on 15th of January by you, so you will get an opportunity to 15th of July. Same way, the appeal, your memorial will be either rejected, it will be modified, your penalty will be enhanced, or it will be reduced, or you may be exonerated, or it will be totally rejected. But in this case, in appeal and memorial, you need to keep it in mind that if the appellate authority or the memorial authority wants to enhance the penalty, so he will convey his mind or his intention of enhancing the penalty before a penalty is been imposed on you, so that you can get a chance to present yourself or make a representation against the intention of the appellate authority or memorial authority. Any question on this? The appeal has to be filed within 90 days from the date of receipt of the disciplinary authority's order, and same way, memorial has to be preferred within 6 months from the date of receipt of the order of the appellate authority. In both the cases, your appeal or memorial will be either rejected, or it will be considered, you may be exonerated, the penalty may be increased or penalty may be decreased, like that. Okay. This is the table which will show you who are the authorities. Now, substaff and equivalent cadre. So, appointment authority is officer in the scale of 4. 4 means manager. Then disciplinary authority can be scale 2, that is assistant manager. Appellate authority will be scale 5. And memorial authority will be CMD. Same way, record clerk officer in scale 4, then Disciplinary Authority 3, then Appellate Authority 5, and CMD. Senior Assistant Development Officer Appointing Authority is 5, Disciplinary Authority is 4, Appellate Authority is 6, and CMD. Now in this case, now I will give an example. Now here the Disciplinary Authority in sub-staff cases officer in the scale 2, that means assistant manager. Now if the penalty has to be imposed, so it has to be imposed in the cadre of scale 4 and above, because they were the appointing authority. Now officers. Officer in scale 1 and 2, the appointing authority is scale 6, Disciplinary Authority is scale 5, Appellate Authority is scale 7, and Memorial is CMD. Then scale 3 is appointing authority 4, Disciplinary Authority 6, Disciplinary Authority also 6, then Appellate Authority is 7, and CMD. Then officer in the scale of 4 and 5, the scale 6, 7, 7, then CMD. Here, Board of Subcommittee of HR is the Memorial Authority. The officer in the scale for 6 and 7, CMD, Board of Subcommittee, HR, and Board. So you can go through this. Hello, friends. Now you will be addressed by Mr. Dinesh Bobade or Bhau for some time. So this session is now terminated for a few minutes. Okay. So over to Mr. Dinesh.
Bhau, you can start now.
हॅलो आवाज येतोय येतोय ना मग सर थांबे
So you are audible.
Yes.
Hello.
Hello. Hello.
Yes, sir. Yes.
Audible.
Yes. Yes. Hello.
Hello.
Jivan, you can hear me? Yes, sir.
Yes, sir. Yes, sir. You are audible.
Good morning, friends. Myself, Sachin Loke, Class 1 Secretary, BVKS All India. With me, I have our General Secretary, BVKS, Shri Dinesh Bobate. We are conducting these classes from last 20 to 45 years. And many of the aspirants are taking the benefit of the same from last many years. irrespective of any union association, we are conducting these classes. And I don't want to waste your time. Just our General Secretary, Mr. Dinesh Bobate, wants to give the good wishes on behalf of BVKS team. So I would like to invite our General Secretary, Sri Dinesh Bobate, to have some few words and give some welcome speech on this occasion.
नमस्कार, प्रणाम, सुप्रभात, गुड मॉर्निंग।
नमस्कार सर।
नमस्कार।
नमस्कार।
आप सभी को भारतीय बीमा कर्मचारी सेना की तरफ से आने वाली 30 अप्रैल को जो विद इन क्लास 1 प्रमोशन एक्सरसाइज होने जा रहा है, क्लास 1 टू क्लास स्केल 1 टू स्केल 4, उसमें भारतीय बीमा कर्मचारी सेना की तरफ से आप सभी को मैं हार्दिक शुभकामनाएं देता हूं। और जैसा कि सचिन लोके जी हमारे जो क्लास 1 के सेक्रेटरी है, उन्होंने कहा कि पिछले कई सालों से इररिस्पेक्टिव ऑफ यूनियन हम लोग ये क्लास कंडक्ट करते हैं। इसी तरह हमें कोविड ने ये सिखाया, हम लोग यहाँ पर मुंबई में पहले करते थे, लेकिन ये कोविड की वजह से हम लोग ने ये ऑनलाइन के माध्यम से पूरे ऑल ओवर इंडिया में जितने भी कैंडिडेट है इस एग्जाम को जो पार्टिसिपेट करते हैं, एग्जाम को बैठते हैं, उनके लिए हमने क्लास शुरू किया। और आपके माध्यम से ये अच्छा रिस्पॉन्स भारतीय बीमा कर्मचारी सेना को मिल रहा है। और भारतीय बीमा कर्मचारी सेना का ये आप जो जिस तरीके से ये अटेंड करने की वजह से जो हमें प्रोत्साहन मिलता है, हमें जो इनकरेजमेंट मिलती है, उसकी वजह से मैं आपको बहुत बहुत धन्यवाद देता हूँ। और आने वाले इस 30 अप्रैल को आपको बहुत अच्छा यश मिले, आपको प्रमोशन मिले, आपकी अच्छी पोस्टिंग हो, इसके लिए मैं आपको शुभकामनाएं देता हूँ। धन्यवाद। जय हिंद, वंदे मातरम।
थैंक यू सर।
Thank you, Jivan. Now you can carry on.
Thank you, sir.
Thank you, sir.
Bye.
कितने लोग हो?
Hello. So we resume our presentation. Hello.
Yes, sir, we are hearing.
Continue, sir. Continue.
So we have discussed about the schedule of authorities. So if you go through it, you will understand. Okay, now we come to suspension. So what do you mean by suspension? The appropriate authority will place any employee under suspension under Rule 20 into bracket 1 if disciplinary proceeding is contemplated or pending against an employee, or where a case against him in respect of any criminal offense is under investigation or trial. So during the service of your service period, you must have come across some people who have been placed under suspension. So what do you mean by suspension? Suspension means what? Yes, Sanjay ji, boliye.
Till the order comes, you are under suspect condition.
50% of the salary is payable.
No.
Temporary termination.
First of all, what is suspension? You should understand.
The period until your charges are confirmed. You are.
No, it's not like that. Say, suppose if a person has committed a serious misconduct, likewise he has misappropriated the premium, or he has settled some bogus and fictitious claim, and there are chances that this person is likely to tamper with the office record. So he has been placed under suspension. That means he is not allowed to come to the office, do his regular job. So suspension in a layman's language, it's not a literal meaning, but in a layman's language, I can explain. I can tell you, suspension is nothing but a temporary termination of contract of employment. So he is no more required to come to office, work, sit at table and do some work. So he has been kept away from the offices. And when this sort of action is required, when a disciplinary proceeding is contemplated or pending against an employee, I told him if the misconduct committed by him is very serious or grave in nature, then such employees are placed under suspension. Or supposing if a criminal case has been registered against him. Now, supposing someone has robbery में कुछ तो he has been caught for caught during robbery और उसने किसी का murder किया है, so such person will be placed under suspension immediately. This is called suspension. You understood, or you want some sort of a clarity in this?
Yes, sir. Please give one example.
Yeah. Now see, this is suspension means we'll be making the office order to that effect. Now there is one more suspension that is called deemed suspension. That is assumed. What happens now? A person has been caught for doing some sort of a criminal offense by the police department, and he was kept under the police custody for more than 48 hours. And you will never come to know whether he was caught by the police department or not. So supposing if a person has been caught and you come to know and he could not get his bail within 48 hours of his detention, then such person will be deemed to have been placed under suspension from the date of his detention by the court, by the police. So now there is a catch. From which time, from where you have to count 48 days. Now supposing if a person has been caught on 5 p.m. on Friday and Saturday, Sunday is holiday, that is weekly off. And Monday he was produced before the court and he obtained bail. So from where you are going to count this 48 hours? From what date you are going to count this 48 hours? See, because he's got the bail on Monday, that means had the court been working on Saturday or Sunday, he could have got the bail. So in that case, that would not have been 48 hours. So therefore, while calculating the 40 hours, the intervening holidays are not to be taken into consideration. So here we'll find Friday he was produced before the court, Saturday, Sunday being holiday, those days will not be included. But Monday when he was produced before the court and he got the bail, so he is not exceeding 48 hours. You understood this? Did you understand this?
Sir, please clarify
Yes.
once again.
Huh?
Please clarify once again the 48 hours condition.
Yeah, see, the counting of 40 hours will commence from the date of his detention, date and time of his detention by the police department till he gets the bail. Now, I have given you an example that at 5 p.m. on Friday, he was detained by the police department.
Yes.
Saturday, Sunday being holidays, court were not working. So he was produced before the court on Monday, say at 12 o'clock, and he got the bail. So now here, the counting of 48 hours will be from 5 p.m. excluding Saturday and Sunday.
Okay. Okay.
You understood?
Sir,
Okay,
why it
sir.
is excluded?
Pardon?
Why Saturday, Sunday is excluded?
So because those are holidays now, intervening holidays. So assuming that he was detained on Thursday and Friday was court day, court working day. He was produced on Friday before the court and he could get the bail. So 48, his detention is not exceeding 48 hours. Same way, he was detained on 5 p.m. on Friday and Saturday, Sunday being holidays. So he could not be produced on Saturday and Sunday. So therefore, those intervening holidays will not be taken into account while calculating the 48 hours. Understood?
If he's
Yes, sir.
so if the bail is allowed to on a Thursday or next year from Monday, then 48 hours.
See, madam, what I told you, you have to count the date, count the time from the time and date he has been detained in the policy by the police department, excluding the period of holiday, intervening holiday.
Okay, sir. Thank you. Okay.
Yeah.
Sir, what is the meaning of revoking?
That I will explain it to you now. Actually, you want me to explain now only? See, suspension means what? You have to pass an order that Mr. So and so working as so and so, SR number so and so, has been placed under suspension pending disciplinary proceedings against him with immediate effect. Okay, so that will be signed by the person who is placing him under suspension. Now, after 1 month, 2 months, 3 months, he finds that now everything is okay. Everything is okay means all the records have been seized by the company. He is not likely to tamper with the office record, nor he is going to influence the witnesses because the investigation has already been carried out. So instead of paying him 50% or 75% without doing anything, it is better we ask him to join the duties so that at least he will do something and he will get his salary. So that time his suspension can be revoked by the authority who has passed the order. Revoking of suspension means he will no more be under suspension. He will be required to resume his duties. So understood? Hello? Understood?
Yes, sir.
Yes, sir.
Now you have placed the person under suspension. I will tell you suspension is not a penalty. It's a just precaution taken by the management to ensure that he doesn't interfere with the office record. He neither influences the witnesses, not tamper with the office record. So therefore, he is not at, and you see, unless and until he is proved guilty, he is not guilty at the moment. Therefore, by placing him under suspension, you cannot deprive him of his right to live, or his family is also there who is depending upon him. So therefore, the management has made this rule number 21 that if a person has been placed under suspension, pending inquiry, pending criminal proceedings, so he will get 50% of the monthly gross emolument for first 6 months of suspension. Now, if a person has been placed under suspension on 1st of January, so till June end, he will be getting 50% of the gross emoluments as suspension, as subsistence allowance. Now, after 6 months, the competent authority will take a review of the suspension period and will say that who is at fault, whether the matter against him is pending because of non-cooperation of the employee or there is a delay on the part of the management in completing the inquiry. Supposing if management is at the fault, then subsistence allowance from 50% it will be 75%. From 50% it will be enhanced to 75%. But if the employee is not coming forward and is not cooperating in completing the inquiry, then it will be reduced to 25%. Now, supposing if a person is getting a subsistence allowance of say 10,000 rupees, which is 50%, that is 20,000 was his salary, 10,000 rupees he was getting. So 10,000 rupees for 6 months he will get. After 6 months, supposing if he is cooperating with the management and management is unable to complete that inquiry, it will be increased to 75%. That means he will get 75%. That is 15,000 rupees. Now, supposing if he is not cooperating, so from July onwards, he will get only 5,000 rupees. Understood now? Hello? Have you understood this?
Yes, sir.
Yes, sir.
But under any circumstances, supposing if a person has been detained in the police custody, so for that police custody period, he will not get any subsistence allowance. Now, assuming that he has been caught by the police on 1st and he got the bail on 20th, so up to 20th, he will not get subsistence allowance, and subsequently 50% of the subsequent allowance can be given by the management on the merit of the case. Now, treatment of period of suspension, that is under Rule 22. What I told you, that suspension, when a person has been placed on suspension, you never know whether he will be found guilty or not guilty. Therefore, you are paying him subsistence allowance. Now, supposing after the inquiry, he has been exonerated by the office or he has been acquitted honorably by the court, then in that case, he will be getting the full pay and allowances. Now, supposing if he was getting 20,000 rupees subsistence allowance and you were paying him 10,000 rupees, the difference between 20,000 and 10,000, that is extra 10,000 rupees for 6 months, that is 60,000 rupees he will get as if he has got the salary for all the 6 months because he has not been found guilty. Okay. Then see, he was not at fault. He has been exonerated. He has been acquitted. That means the charge sheet issued to him or the criminal proceeding initiated against by that particular employee was not correct. Therefore, the period of suspension will be treated as if he has spent that period on duty. So what will the first, if he has been honorably acquitted, he will be getting the difference between the subsistence allowance which has been paid and the actual salary. Okay. Then the period of his absenteeism will be treated as if he has spent that period on duty. But assuming that he has not been exonerated, he has been found guilty, or he has been convicted. In that case, under no circumstances, the subsistence allowance will be recovered from him. If he has been found guilty, he will not be that allowance will not be recovered from him. If he has been convicted, then also if that subsistence allowance, whatever has been paid for that period, will not be recovered from him. Any question on this?
No, sir.
No.
Sir, if he is honorably acquitted, then the time period on which he was not attending the office will be considered as leave.
No, I have said that. See, you are not understood this second point. Then his period of absence from the duty will be treated as period spent on duty. See, 6 months he was 6 months he was not on duty, but subsequently when he has been acquitted or he has been exonerated, so that period will be considered as if he was on office duty. Understood? Cleared?
Okay, sir.
Now we were talking about defense assistant that time. And inquiry में कौन रहता है? Inquiry officer, presenting officer, then charge sheeted employee, and if he wants, he can hire the services of any employee who will be called as a defense assistant to enable him to defend his case properly before the inquiry officer. So who can be defense?
सर प्रीवियस स्लाइड में आपने ये बताया अगर वो एक्विटेड होता है, अगर सस्पेंड होता है, गिल्टी पाया जाता है, फिर उसका ट्रीटमेंट कैसे होता है?
उसका ट्रीटमेंट क्या, उसको अभी देखो, उसका यानी जो सब्सिस्टेंस अलाउंस जो दिया है ना, सब्सिस्टेंस अलाउंस जो दिया, that will not be recovered under any case.
What about the time period suspension?
Period. Now, supposing if he has been found guilty, so the period of suspension will be confirmed. So that will be not counted as his service period.
So it will be taken as leave. Then what that period will be counted like as a leave on leave or?
No, that will be, that will be break in service for 6 months. Now at the end of this service tenure, when his service period is calculated, so this 6 months or 10 days or 15 days or 6 months, 1 year, 2 year period, what he has spent on suspension, that will be confirmed. So that much period will not be considered as period spent on duty, and that will be deducted from his entire service period. Understood?
Okay, sir.
Yeah. Now we were talking about defense assistant. Likewise, we hire an advocate to defend our case in court.
Excuse me, sir. In last topic only, it is mentioned in CDA rules that if he is found under point B, that is, if he is found guilty, it is up to the competent authority to consider that period as he can grant leave. He can is it like that? It is mentioned in CDA rules.
Consider means, see, I will tell you one thing. What happens now, you cannot pick and choose. See, there has to be, the decision has to be equal for all. Hello?
Sir, किसी ने mic unmute कर रखा है.
So the thing is that period has, see, therefore I said once the penalty has been imposed, then that period is confirmed. That period is confirmed. Only thing that because he has not been dismissed, he will be continuing with the services of the organization, and at the end of the service his tenure, this 6 months will not be counted as period spent on duty.
But competent authority can take it as a leave also. Okay, they have that power.
It cannot be done. That is what I am telling you now, madam. What happens now? There are n number of people who have been placed under suspension. So management, the rule is like that. But up till now, see, even I have handled n number of cases of suspension. So nobody has been given any reply by of considering that period spent on duty. See, finally they have been found guilty. No, so what is the fun in considering that period spent on duty? It will never be done. Okay.
Okay.
Now this defense assistant. I have already told you defense assistant means nothing but a person who will be trying to defend the charge sheeted employee before an inquiry officer. Likewise, we hire a legal practitioner or an advocate when we are contesting any case in the court. But you can appoint a defense assistant, but he has to be necessarily an employee of the company only. That means he should be an employee of New India only. He cannot be an employee of National, Oriental or United or GIC or the Agricultural Insurance. He has to be necessarily an employee of the organization. And he should be from the same region. Now, if an employee is working under Ludhiana Aro against whom the disciplinary proceeding is going on, he cannot ask that I want a defense assistant from Calcutta. He has to necessarily take the defense assistant from the same place where he is working. Or place means that region. But there is an exception where, like in Mumbai, there are 5-6 regional offices, LCBO and all. But that comes under one area only. So therefore, a person who has been issued charge sheet, though belongs to MRO1, he can seek the defense. He can seek the assistance of any employee who is from MRO2, 3, 4, 5 LCBOs and all. Okay. Then legal practitioner cannot be engaged as defense assistant. You cannot hire an advocate and come with him before the inquiry officer. Because he is not an employee. Secondly, legal practitioner by way of our rules cannot be engaged as defense assistant. Then, supposing if a person is already a defense assistant, but it has to be ensured that he is not acting in more than 2 cases at a time as defense assistant. See, if I am an inquiry officer, I will ask defense assistant whether you are working as a defense assistant in other case. If he says yes, 3 cases, I will say no. Now 4th case cannot be given to you. Now, even in fact, 3rd case should have also not been given. You are already working in 2 cases, so you cannot be given a 3rd case as a defense assistant. But the charge sheeted employee insists that no, in spite of that, I want him to be the defense assistant. Then inquiry officer can allow him to work as defense assistant, but such employee who is already working as defense assistant in 2 cases will not be entitled to be treated as if he is on official duty. Now, I am from Pune. I want a defense assistant from, say, Bombay. So what the charge sheeted employee will be required to do is to make his presence available before inquiry officer at his cost. At his cost. So no TADA will be payable to him if he is acting as DA in more than 2 cases. Any question on this? Any question?
No,
on
sir.
This?
No, sir.
Now, this is a recent amendment to CDA rules. Rule 422, no employee shall engage in any act of sexual harassment of any woman at her workplace. See, actually, we are working with our female colleagues also. And you know, at home also we have got our wives. हमारे लड़की रहती है, sister रहती है. All ladies are there now who are related to us. So how do we interact with them? How do we treat with them? Same way, same sort of an gesture should be shown towards our female employees. We should not indulge in passing any unnecessarily unparliamentary comment against him, neither try to spread some sort of a rumor, gossiping. And supposing if someone is caught and that lady approaches the office, then believe it on me that that person will not be let off like that only. There are n number of cases where people have been terminated.
Sir,
yeah.
सर ये शायद रूल नंबर 4023 है.
23 है?
Yes sir. 22 तो शेयरिंग ऑफ कंप्यूटर पासवर्ड IT एक्ट से रिलेटेड है.
Okay, आप वो देख लेना जरा प्लीज. Good. It is 23. Now I'll make a change in this. Typing में कभी-कभी mistake हो जाता है. But so far as rule is concerned, forget about the rule number. Is it? Have you understood it? Hello.
Yes sir. Yes sir.
Okay. Now we come to pension rules. Pension is subject to good conduct if convicted, withdraw or withhold pension or part thereof. See, even after retirement, your conduct should be good. Now, subsequent to your retirement, you are getting pension. And if you have been convicted, then the management can decide to withdraw the entire pension or withhold some part of the portion. Then guilty of grave misconduct, that is rule number 43. See, a person who retired from the services of the organization, and if any misconduct which he has committed while he was in the services of the organization, and that is a grave misconduct, and from the cause of action or the action which he had taken to commit a misconduct, from that day till now, if more than 4 years is not over, then action can be taken against him. If more than 4 years are already over, then no action can be taken against him. So the cause of action which arose should be 4 years before initiation of any action. Now, supposing if a person has retired on say 31st of December 2025, okay, and he has committed a misconduct, say on 31st of December 2019, then 4 years is not over, because only 1 year, this is before 1 year of his retirement. And still 3 years are there. Within 3 years, you can take action. Same way, if you go to 18, then 2 years. Then next 2 years, that is up to 24, you can take action. Same way. So the action of misconduct which has occurred, from that date, you have to take 4 years after his retirement. But if a person is in service and at the time of his appointment, if he has committed any mistake, and before his retirement, 2-3 days before his retirement, if that misconduct is noticed, still action can be taken against him. It is only this 4 years clause is only in case of the people who have already retired from the services of the organization. Any question on this?
Sir, rule number 43, I can't see where is it. It is in CD rules.
It's not
rule
written.
Number 43.
That is in pension rules. See, it is pension rules what I have said. It is pension rules.
Sir, can I got it from your slides? Pension rules. I have no circular about this.
Where you are working?
Sir, under Ludhiana.
Ludhiana, you can get a pension rules now from there. Pension booklet is there. You go to rule number 43.
Ji, okay, sir.
Yeah. Any question on this?
सर ये लास्ट वाला पॉइंट फिर से बता दीजिए सर. कॉज ऑफ एक्शन.
आप एक काम कीजिए, आप एक पेपर और पेन लीजिए.
यस सर.
हाँ, आप उसमें एक लिख दिए कि 31 दिसंबर 2021 को रिटायर हुआ है. लिखा आपने?
हाँ सर, 31 दिसंबर 2021.
4 साल पहले की डेट लिखो आप. वही 31 दिसंबर. अभी ये हम 21 हो गया ना, तो यानी 20, 19, 18, 16,
17 तक सर.
हाँ 17. ये जो पीरियड का जो है, नाउ सपोज इफ 1st of January को अगर if something is known that he has done on 31st of December, so you cannot take any action, though it is only 1 day after his retirement. अभी उसके बाद में का डेट देखो, 18 का डेट देखो, 18 का मालूम होगा तो स्टिल देर इज one year's period left. So within 1 year you can take action. 19
Okay, sir.
हाँ.
Okay, sir.
But sir, if he has retired, but some fraud or something has been detected after his retirement, but during his period of work, then also we can't.
But see, that the cause of action, what misconduct he has committed, na? When did you find that is good? That doesn't have any meaning. When he has committed that mistake, from that day you have to count 4 years.
Okay, when detected is not to be considered, but if he is retiring in 2019 and he has done something in 2018 and it has been detected in 2020, then also from 18 we will count 4 years.
Yes, correct. Exactly, you have understood the concept. Very clear. Okay. Now see, if a person against whom the disciplinary proceedings is going on, no action has been taken against him, then he will get the provisional pension. Now what is provisional pension? See, we are supposed to get 1/3 of the pension commuted. So instead of, he will not be allowed to commute that pension, but he will be getting 100% pension. That is, if his entitlement is, say, his basic was, say, 20,000 rupees, so he is entitled to get the pension of 10,000 rupees, basic pension. So he will get basic pension plus DA. Had it not been, I mean, supposing if he was not to be tried and under any CDA rules for disciplinary proceedings, so he would have got 10,000 rupees, say 1/3 he could have been able to commute, and he could have got the lump sum amount against the commuted pension, which he will not be entitled in this case. Now, if found guilty, gratuity and company's contribution toward PF is not payable, but encashment of leave is payable. That I have already explained it to you earlier when I was talking. When somebody asked, there, supposing if a person has been dismissed, removed, or terminated, so what will be paid of his terminal dues? So he will not get the gratuity, he will not get the company's provident fund if he is opted for PF, but he will get the leave encashment. Now, PF own contribution and VPF is pension. VPF is payable. I have told you that by any order of court, tribunal, or forum, the attachment to PF and VPF cannot be done. So PF and VPF, that is your own contribution. Therefore, even if an action is been initiated against you, your PF and VPF cannot be returned by the company. Any question on this?
No, sir.
Now, all employees are required to submit their annual property returns by 30th of April every year, giving description of property acquired, sold by them during the preceding year. So I believe all are submitting this property return. It is now online. All are submitting, na?
Yes, sir.
So you need to mention there and what property you have acquired, what property you have sold during the preceding years, and property and your balances also. Because see, what is the use of submitting property returns? That is as per rule number 16. Can someone tell me? प्रॉपर्टी रिटर्न भरने का फायदा क्या है?
सर ट्रांसपेरेंसी रहती है.
ट्रांसपेरेंसी विथ whom?
सर कंपनी के साथ कि हमें जो भी सैलरी मिल रही है
ठीक है, लेकिन उसका फायदा क्या है? कि आपने बता दिया करेक्ट है, फायदा क्या है?
सर कंपनी एम्प्लॉय की इनकम और उसकी प्रॉपर्टी में एक कंसिस्टेंसी होनी चाहिए. यदि उसके पास प्रॉपर्टी है तो इसका मतलब उसने कुछ फ्रॉड के थ्रू कमाई है.
करेक्ट. इसीलिए see, it is always said that this is called a DA case, that is disproportionate asset case. Now, if your annual income is such, I mean, supposing if your annual income is 5 lakhs rupees, can you purchase a property of 10 lakhs rupees during that year? Because you need to consider your other expenses also. Out of that, how much would be your saving 1 lakh, but you are invested in 10 lakhs. So definitely you will be asked by the CBI. So see, The benefit of submitting property return on yearly basis is that supposing at the end of your service tenure, CBI comes into know that you have acquired so much of property, but simultaneously they come to know that you have submitted your property returns also every year, so they will not ask you. Because the moment otherwise, what will happen? You will not be able to answer them properly. They are from which sources you could acquire this property, why your cash balance is so much and all. So that is the profit. That is the benefit of submission of your property. Because every year, see now, supposing if someone has joined recently, his entire this annual package may be 6 lakhs. Now at the end of his tenure, likewise people like me who retired, so our annual package was 18 lakhs rupees. Now your starting salary may be 1 lakh rupee a month. So after 20 years, 30 years, it may be 50, 60, 1 crore also. But you have gradually acquired this property, and for that you have already submitted your return to the offices. Therefore, CBI will not be in a position to question about your integrity in acquiring so much of a property. Understood? Understood or what?
Yes, sir.
Yes, sir.
Now, have you heard about Central Vigilance Commission?
Yes, sir.
Yeah, the Central Vigilance Commission, our all vigilance department work under Central Vigilance Commission. And earlier now the cases, I mean vigilance cases of scale 3 and above were referred to CVC for seeking their first stage and second stage advices. But from September 2007, now officers which are coming in the cadre of chief manager, that is scale 5 and above, are coming under the purview of CVC. That means if any action has to be taken against chief manager and above, either to issue them charge sheet, either to exonerate them, either to implicate the penalty, so that will be done after getting the consent of Central Vigilance Commission. Sometimes you may be asked the question that which officers come under the purview of CVC. So you have to just write down chief manager or scale 5. Now, sanction for prosecution. See, are you all aware that we are all public servants? Hello?
Yes, sir.
Yes, we are all public servants. So as a public servant, if CBI wants to take any action against them, now though, even if CBI wants to investigate a matter against any employee, they have to take the permission of the office. If our office says that no, they will be able to look into this matter through our departmental inquiry only, CBI cannot force. Now, assuming that you have given permission to investigate the case to CBI. Now, CBI on completion of the case wants to file a case against that particular employee. But our disciplinary authority says that this is not a case which fit to be which is not fit for prosecution, so we don't allow. So that disciplinary authority can do. But supposing if CBI and disciplinary authority is not coming to the agreement, CBI says no, we want to prosecute him. Our employer, that is our organization, say no, this is a disciplinary matter. We'll look into this. And if there is a difference of opinion, that matter will be placed before CVC, who will take the final decision. And it has happened. Now, some of you must be working with Mumbai. Is anyone from Mumbai? Anybody from Mumbai?
Yes, sir.
Yeah. So I'll just give you an example. So there was one case with Moti Mahal building. So CBI wanted to prosecute them. So there was quite heavy exchange of correspondence between CBI and our department. But we were firm that we are not going to give sanction for prosecution, because that was the case where our employees have not played that major role. It was pertaining to surveyor and garage owners. Then still they did not agree. Then finally the matter was placed before the CVC. So we had a meeting at CVC, and I had an opportunity of visiting CVC's office that time, CBI and ourselves. And I was representing our company. So that time there was a discussion across the table. And finally, the points raised by me before the CVC were agreed, and they did not give agree for giving sanction for prosecution. So you can understand that department is not only after the employees, but they try to protect employees also. And finally, those people will be issued a charge sheet, and most of them were let off by a censure or a minor penalty. So this is sanction for prosecution. Now somebody had asked me right in the beginning that if an employee who is found guilty and penalty is imposed, then he will not get promotion. That is called rigor effect. Supposing if he has got a major penalty, he will not get promotion for 2 years. If he has been imposed with a penalty of minor penalty, he will not get the promotion for 1 year. And censure, supposing today he has been censured and tomorrow the list is going to be declared, he can get the promotion.
Sir, can you repeat this point? Sir, please come again.
If a person has been imposed a major penalty, so he will not get promotion for 2 years from the date of imposition of that penalty. Now, unfortunately, supposing if that person has been imposed a penalty now, and the next exercise is coming in September, he will not get that promotion. Then again next September, he will not get promotion. He will get promotion only after 2 years of major penalty. Same way in minor penalty, if he has been imposed with a minor penalty now in April, exam is coming in September, he will not get promotion in September, but next September after completion of 1 year, he will get the promotion. But a minor penalty is also censure, because I told you censure is nothing but a recorded warning. So supposing if a person has been censured and tomorrow the list is going to be declared, then he will get the promotion. For him, there is no rigor effect.
Excuse me, sir. What about effect on stagnation increments of these penalties?
See, stagnation increment, that depends upon the person who will be writing his CR. And if the action is pending against him, he will not get. And if major penalty is imposed against him, then also he will not get, provided that that misconduct is pertaining to the year in which he was entitled to get the stagnation.
Sir, can you please repeat this point? I'm not able to understand.
Pardon?
Sir, can you please repeat this point?
See, if any investigation is pending against him, okay, so you will not get the stagnation increment. Now you saying that the major penalty is imposed, that means the investigation which was going on against him during that period has come true. I mean, he has committed a misconduct, so he will not get stagnation increment for that period.
Sir, like in case of censure, we are saying it next day, it will have no effect. And during the period, suppose the period of investigation is like 2 years. And in which he was supposed to get the stagnation increment, which we withhold because of that inquiry.
So that will
and
not
after
be
that,
released. That will not be released because the investigation is going on. And
but
tomorrow, supposing after the investigation, no fault has been found on his part, so that time stagnation increment given from that retrospective.
And if he get only censure, then what about stagnation increment?
See, it will be depending upon the disciplinary authority now.
Sir, if a person is under suspension and the inquiry is going on, but inquiry may take any time, like 1 year or more, but in between that there is a promotion exercise. So
I will explain it to you. I'll explain to you. It is in next chapter.
Okay.
This password. Now, what do you mean by password? What do you mean by password?
Swiss password. Swiss password.
Pardon? What do you mean by password?
System passwords.
So system ka, but what is meant by password? Anyway, because I don't want to take much of your time. Password is a word which is given to you exclusive for your use for having access to the system. Am I right? Am I right?
Sir.
Yeah.
Yes, sir.
Yeah.
Yes, sir.
So see, tomorrow, supposing if your password you share with someone and he commits any misconduct, so whose fault will be there? The person whose password is appearing in the system. So it is not to be done. This is also a misconduct. Now, procedure for imposing minor penalty. I have already explained it to you. First will be investigation, then issue of charge sheet, then written statement of defense. Here, no inquiry because this is a minor penalty. Then order of the disciplinary authority. Then major penalty.
Excuse me, sir.
Yeah.
So in this procedure, rule number 3, what is the maximum period granted to an employee for giving his statement
of defense? I told you now 15 days. Now
the
supposing
maximum
if he is unable to submit within 15 days, he need to place a request before the disciplinary authority for his consideration.
So maximum period is 45 days or
15 days. 15 days that can be extended at the discretion of the disciplinary authority.
okay, at the discretion of the
Disciplinary authority, the person who has appointed, who has given him a charge sheet.
Okay, so okay.
Now procedure for major penalty, investigation will be there, then charge sheet for major penalty will be issued, then he will give his written statement of defense, and here the disciplinary proceeding will take place by appointing IO and PO. Then IO will submit his inquiry report, and then disciplinary authority by application of his mind will decide what sort of penalty has to be awarded to him, whether he has to be exonerated, whether minor penalty has to be imposed, or whether any major penalty has to be imposed. Now, judicial proceedings, inquiry proceedings. Now, there are two types of proceeding. One is judicial proceeding and the other one is quasi-judicial proceedings. So, ours is quasi-judicial proceeding because it is on the basis of the proceeding which is being done, conducted before an appointed judge. So, here the inquiry officer, presenting officer doesn't enjoy the status of a judge or a prosecution advocate. This is the department, and see, today I'm appointed as an inquiry officer, so I'll be inquiry officer for this particular case. I am not a inquiry officer always. Whereas the judge, whether he is whether any matter is pending before him, or there are n number of matters pending before him, or there are likely to be n number of matters coming before him, he is a judge. So that is the difference. So in this is just for the comparison. In court proceeding, there is judge, whereas here it is inquiry officer. There is public prosecutor, whereas here is presenting officer, domestic inquiry. Accused, we call him charge sheeted employee. There is a defending advocate, we call him defense assistant. I think this is very simple, you can understand. Now, rule number 39. Even if no appeal is made, appellate authority on its own can call for the papers and see if the penalty is incommensurate with the nature of misconduct, can enhance, reduce, or exonerate. Now, sometimes what happens, some people are not aware that whether they should prefer an appeal or not. So, in between, sometimes people try to create fear in his mind that if you make an appeal, the penalty will be increased like that. So in that case, now supposing even if the appellate authority knows that one case is there where the penalty is not incommensurate with the misconduct committed by or proved against him, so he can call for the paper. Then on his own, he will take a decision either to reduce or enhance the penalty or exonerate him. It has happened. Any question on this? Any question on this?
no, sir, no, sir.
No, sir, it's clear.
Now, disciplinary authority's role after receipt of inquiry. See, inquiry has been conducted. He has submitted his report. So, disciplinary authority will go through the entire report and find whether the conclusion drawn by him or his findings are based on the oral and documentary evidence placed before him. Sometimes what happens, the inquiry officer try to save someone, he will say that charges are not true, even though there are sufficient evidence to prove his guilt. So that time, disciplinary authority has got a prerogative to disagree with the findings of the inquiry officer. If he agrees, there is no need. And if he disagrees means then he will have to, give the reasons in writing that why he is disagreeing with the findings of the inquiry officer and why he is coming to the conclusion and what are the reasons. That will be communicated to the charge sheeted employee, and based on that, his representation will be called. Otherwise, he is also got a prerogative to remit this inquiry afresh, and by appointing a newly inquiry officer. So what he can do, he can agree with the findings of the inquiry officer, then necessary action will be taken. He can disagree, but while disagreeing, he has to give the reasons. He has to record the reason for his disagreement and record his own finding by giving justification and send it to the charge sheeted employee. Or simply he can say he can declare this inquiry as null and void, and he can remit the inquiry afresh to a newly appointed inquiry. Any question on this?
No,
No,
sir.
sir.
This gratuity calculation you must be knowing, but still I'll just read for yourself. As per Act, basic plus DA plus allowance divided by 26. That is, this comes as a monthly salary for a monthly salary, which is to be divided by 26 days. That is, then the salary comes for 1 day. Then multiply by 15, again multiply number of years of service. This is as per Act. Then as per scheme, this is basic plus FPA divided by 2 and multiply by number of years of service, or rupees 26 lakhs, whichever is there. Either as per Act or as per scheme. Supposing it is coming as per scheme 20 lakhs, then you will be paid 20 lakhs rupees. Though as per Act, it will be less. Okay. Any query or doubt? With this, Annie, I have completed presentation on HR Legal.
Sir, I want to ask if any employee wants to resign from his service, sir.
Okay.
How much period before he has to intimate to the company?
3 months period, 3 months notice.
3 months. And if he is quitting the office by 30, giving 30 days notice, then what is the status?
30 days notice, 2 months, 2 months period, or 2 months salary you will have to give to the company.
2 months salary.
See, because 1 month notice he has given, 1 month
Yes.
he will be there in the service, and actually mandatory 3 months period of notice is required before someone is asking for resignation, retirement, anything. So 3 months, if you are not able to complete that 3 months of mandatory period, then you are supposed to pay 3 months salary. If you are able to complete 1 month, then 2 months salary you have to pay. If you are able to complete 2 months, then 1 month salary has to be given to the company. Anyway, 3 months period you spend or 3 months salary you deposit with the company.
Okay. Thank you,
Sir,
sir.
gratuity is tax-free up to what amount? 20 lakhs.
20 lakhs.
Flat 20 lakhs, now whether it is as per scheme you are getting or as per Act.
Act.
Sir,
Yeah.
the different type of pension देखने को मिलती है, जैसे compassionate pension, valid pension, invalid pension, और एक अभी आप बताए जैसे provisional pension. Sir, इसमें थोड़ा क्या difference है वो बता दो.
So provisional pension है क्या? Any when some case is going against you and you cannot be paid the full pension, cannot be paid commutation. That time you will be getting 100% per pension, which is equivalent to which will be your provisional pension. The other one is what? Compassionate pension. You said compassionate pension, na?
Yes, sir.
See what happens, supposing if a person after his retirement has committed any misconduct and he has been convicted. So that time his family member, because pension is given with the social, because that is a social cost. So that time the family members can represent before the competent authority for release of compassionate. Other one is what?
So valid pension and invalid pension.
Valid pension means it is, we all are getting valid pension.
And
Sir,
about invalid.
This is invalid or compassionate, जो pension है ना, that is one and the same.
Okay.
Sir, in consideration of service period, in case of VRS, it is considered at least 20 years prior
Yeah.
service. But sir, in case of ex-serviceman, is there some of their period of service is considered in this?
That is always considered, na. See, they have been taken by taking into consideration their service period also, na.
Means if they have served 15 years in army or
Yeah, correct,
whatever,
correct. So
then
that
15 years plus if 5 years they serve in New India.
Yeah.
So that will be considered 20 years of service for VRS?
See, you'll have to check good this. I will keep it in mind because see, supposing if they are getting pension from that service also.
Yes.
Because that will amount to double pension, so that time it will not be considered. But still, anyway, I will share this information to you once I go through the pension rules. Good question you have asked. I have noted it down. Okay.
Fine.
Any other? See,
Madam,
now
can
we'll
you
be going,
repeat your
now we'll
question
be
once
going
again?
to one session that will be question answers. So each one of you will be required to answer. Okay.
Excuse me, sir.
Yeah.
Sir, what is the time period for getting invalid pension? Minimum time period.
Minimum time is that has to be placed across the competent authority, and they will take their time to dispose it of as early as possible. Normally, they should do it as early as possible. But there may be certain, supposing if there are certain hiccups in that particular matter and some legal advice is required to be taken, and also once that is been taken, so they will convey their decision. Okay, we'll go to our question answer.
Sir, I had two small queries.
Yeah.
One is 48 hours debarment.
Pardon?
48 घंटे की जो कंडीशन बताई थी एम्प्लॉय की सस्पेंशन की, अगर सैटरडे को वर्किंग है कोर्ट का तो सेकंड सैटरडे को कोर्ट बंद होती है।
देखो मैं वही बोला, अगर हॉलीडे, आई सेड इंटरवेनिंग हॉलीडे, टू मेक इट वेरी क्लियर टू यू।
सर मेरा क्वेश्चन पूरा होने दीजिए सर, मेरे क्वेश्चन डिफरेंट है थोड़ा। सैटरडे को अगर उसमें एम्प्लॉय को प्रेजेंट किया जाता है और सैटरडे को कोर्ट ये कहता है कि ट्यूसडे को इसे प्रेजेंट कीजिए, तो उसका मंडे भी काउंट हो जाएगा 48 आवर्स में। इन दैट कंडीशन व्हाट हैपेंस?
बेल का जो रहता है ना, बेल का जो रहता है ना, इट इज इमीडिएटली डिस्पोज्ड ऑफ।
अच्छा। सेकंड थिंग इज,
अगर वैसा होता है, व्हाट यू आर सेइंग, दैट इज आल्सो अ वैलिड पॉइंट। नाउ सपोजिंग बिकॉज़ ऑफ द heavy number of cases, large number of cases before the court, and courts they direct them to present on Tuesday, so it is not his fault, and Tuesday if he gets a bail, then that will be intervening period will not be counted as if he was under the police custody or detention.
ओके सर। सेकंड क्वेश्चन इज सर, अगर कोई डिपार्टमेंटल इंक्वायरी है और साथ में सीबीआई या एसीबी का पैरामीटर भी चल रहा है और डिपार्टमेंटल क्वेरी खत्म हो जाती है, लेकिन सीबीआई का केस चल रहा है, उस केस में क्या उस ऑफिसर को एडमिनिस्ट्रेटिव और फाइनेंशियल अथॉरिटीज अलाउड है या नहीं है?
मेरे को फाइनेंशियल अथॉरिटी जो है वो तो दैट विल बी डिपेंडिंग अपॉन द मैनेजमेंट, उसको क्या करना है। See, normally what happens, I'll tell you, if a person has been already involved in any CBI case and all, they will not be assigned with any development function, and he will not be assigned with any financial authority.
And what about the administrative functions?
Administrative function, he has to do it. Now, if he has been kept in the services, he has not been under suspension, then definitely he has to do the administrative work.
Okay, sir. Right, sir. Thank you, sir.
Yeah.
So my previous question that whether if an employee is on the suspension and the promotion exercise come in midway, he will be considered
good
or not?
question. So I will tell you, supposing if a person against whom the disciplinary proceedings is going on, or against whom the suspension, there is a suspension, So actually that question is there in the question answers, but anyway, I will explain it to you because you have asked. Such person, they will not get the promotion, but since they are eligible to get the promotion, they have qualified, they have got number of years of service, they will be facing the interview, that will be there. So accordingly, their marks will be counted, and the chronology, the list will be prepared. The list of the promotees will be prepared, and they will be considered as if there is no action against this employee. Okay.
And if he gets promoted?
No, just listen to me. So that list will be prepared. So the topmost will be on number 1, second topmost, and the last one will be on last. So wherever this person fits in, now supposing there are 50 vacancies, and his merit list number comes to 48. So he will be placed under 48 only, because you still don't know whether any action, whether he is going to be found guilty or not. But since action is being initiated against him, his name will be kept in sealed envelope. He will not be declared promotion, but his name will be kept under the sealed envelope. And once the promotions are declared, his name will not appear. But when his case is cleared, he has not been found guilty either in court or in departmental inquiry. So his name, his sealed envelope will be opened, and he will be declared from the date of the actual promotion, whenever it was declared. That is called sealed envelope procedure.
Okay, sir.
So we go to this question answers. So one by one, you keep your speaker unmute, and you can answer this. Question
So 3.
हाँ?
Third option.
एक मिनट. Okay, so this is the question. Actually, we don't have that remote with us. Otherwise, this was a very good. Question was So this is the question. Find the odd one out in respect of misconduct of an employee. ठीक है, इसमें तो honesty and hard working आता है. Next question. Now charges proved against a suspended employee. What will be recoverable? 50% of what he was paid, 20% of what he was paid, or entire subsistence allowance paid, or nothing?
Nothing is recoverable.
Nothing is recovered.
Correct. An assistant can be placed under suspension by head of the department, disciplinary authority, appointing authority, or all the above.
Appointing authority.
Head of the department.
Disciplinary.
What I told you, suspension is not a penalty, so therefore, head of the department can place him under suspension. Now, appeal must be submitted within 1 month from receipt of penalty order, 3 months or 6 months.
3 months.
3 months.
3 months or 90 days. Okay. Now, which statement is correct? Department proceedings are quasi-judicial in nature. Disciplinary authority can decide the quantum of punishment to charge an officer. There is no need to provide full opportunity to charge officer to defend his case. department inquiry has to be conducted within the ambit of the principle of natural justice.
Sir, 3, there is no
Huh?
3.
3, sir.
Correct. Because see, if you want to impose a major penalty, so there you need to give an opportunity to the charge sheeted employee. Which of the following is not misconduct? Causing deliberate damage to company's property, absence from employee's appointed place of work without permission or sufficient cause, commission of any act amounting to
The fourth.
हाँ?
Fourth.
Absence from, अरे दूसरे को भी बोलने दो किसी को. Absence from duty for one. Now, which of the following is not a misconduct? Providing discount to client based on claim experience, smoking in the office, neglect of our work or negligence in performing duties, drunken or riotous behavior in the office.
So 1, providing discount to client.
One, correct. Now, which of the following statements are correct? Suspended employee can gainfully employ himself. Can you read this?
No, sir. During the suspension.
No. Can you read this first? Suspension employee can be gainfully employed during the period of suspension. He can work in different offices of the company. He cannot leave headquarters without permission of the office. Before releasing subsistence allowance, he is required to give declaration that during the period of suspension, he was not employed elsewhere.
Third, sir.
Third. Okay. And
fourth
also. So this is not to any. I would like to explain you that supposing if a person has been placed under suspension, so he cannot leave his headquarters without the permission of the office, and so he has to give one more declaration that during the period of suspension he was not gainfully employed elsewhere, and whatever subsistence allowance he is getting is the only source of his income. The disciplinary authority has to decide whether prima facie there is evidence to show misconduct on the part of the employee, whether the misconduct is major or minor in nature, whether there is a sufficient evidence to sustain the charges, or all of the above.
All of the above.
That means you will first find whether there is a prima facie evidence to show that there is a misconduct on the part of the employee. Whether that misconduct is major or minor, that will be also decided by disciplinary authority, and he will see whether we have got a sufficient proof to ensure that the charges are proved. That means it is here, all of it. The essence of ideal inquiry proceeding does not include fair and impartial
So fourth.
Assessment of evidence, timely completion of the inquiry, and business procured by the judge official. See, actually, inquiry should be fair and impartial, and evidence should be based on the assessment only, and inquiry should be completed in time. But whatever business has been procured by charge sheet officer does not have any bearing on the outcome of the inquiry. So, business procured by. The penalty is decided by the disciplinary authority based on which of the following factors? Degree of cooperation in the inquiry, past misconduct proved, sole or common misconduct, deterrent effect, all of the above. See, when the disciplinary authority wants to decide the quantum of punishment to be meted out to any charged official after the charges are proved, so what factors he should consider in arriving at the quantum of all. See, I'll tell you, degree of cooperation is required by supposing if someone comes and he admits the charges immediately. So all the cumbersome procedure is limited to 1 day only. Otherwise, what will happen? Your inquiry officer, your presenting officer, if there is a defense assistant and charge sheeted employee, they continue for this inquiry for 10-15 days. And if the travel is required, lot of money is wasted, lot of time is wasted. So that will be definitely taken into consideration. Even his past misconduct is also to be taken into consideration. Supposing if any charges were proved in past and he is an habitual offender, then the degree of penalty will be definitely higher than what he was thinking about. Sole or common misconduct. Supposing if there is a mala fide intention on the part of 3-4 people, then also the penalty will be of higher degree. Then deterrent effect. Deterrent effect means, well, supposing tomorrow someone comes to know that one person, because he has misappropriated the premium, has been let off by just imposing a penalty of reduction in basic salary by 2 stages. It will not have a different effect. He will say, I will also misappropriate the premium of 50 lakhs rupees and I will be let off with the penalty of the reduction in my basic salary by 2 stages. So that will not be a different effect. But if a person who has misappropriated the premium has been dismissed from the services of the company, then it will have a different effect. So all these factors need to be considered by the disciplinary authority.
Sir, what is mean by deterrent effect? Sir, what is mean by deterrent effect, fourth number?
Deterrent effect means the other should also be afraid.
Sorry?
Sorry,
sir?
See, I'll given you an example. Supposing if a person has misappropriated a premium of 5 lakhs rupees, and you are just, imposing a penalty of reduction in his basic salary by 2 stages. So others will, what they will think, either premium, even if I misappropriate the premium, they are going to impose a penalty of reduction in my basic salary by 2 stages. So that fear will not be amongst the employee. Whereas supposing if a person has misappropriated a premium of say 10,000 and he has been dismissed from the services of the company, it will have a fear amongst all the employees. That means that will have a deterrent effect. Now understood?
Sir, can you explain third option, sole or common misconduct?
Sole or common misconduct. Now sometimes what happens now, see, there is a team which is working. Likewise, you must have heard about the crores of rupees siphoned by the one IT engineer and his wife with United India. So they were working in tandem with each other. They were trying to pass on the unnecessary financial benefit to a person. Some third party who are not the actual beneficiary. They were, generating imaginary invoices. And he was the sanctioning authority and she was generating the invoices. So the sole and common misconduct, sole purpose and common misconduct was on the part of both the employees. So that is called sole and common misconduct. Understood?
No, sir.
See, if any misconduct is committed and there are 3-4 persons who are responsible, they in connivance with mala fide intention and ulterior motive, everyone was knowing that this is a misconduct, and in spite of that they have committed. That means they had a sole and common object of misconduct. Now you understood?
Yes, sir.
Yeah.
Yes, sir.
Now, which authority is competent to review an order issued by the disciplinary authority even if the appeal is made against the said order?
Disciplinary authority.
Yeah, correct. Appellate, no, review. See, once the disciplinary authority has passed the order, what I have told you under Rule 39, that if a person is not going forward for making an appeal, so then appellate authority on his own motion can call for the paper and decide the quantum of the penalty or review the penalty made by the disciplinary authority and can take the decision. Now, if the charge official demand list of documents for submission is required, it should be given. It should not be given at this stage. It depends upon the discretion of the IO. It depends upon the discretion of the P. Charge sheet के साथ जो list of documents देते हैं, if he wants to have this document, so whether this document can be given to him.
First should be given.
It should not be
It
given
should
to
be.
him at this stage, because at that stage he has to only say whether the charges are admitted by him or he is denying the charges. Now, which is not provided in CDA rules of the company: appointment of IO, appointment of appellate authority, memorial to general manager or memorial to CMD.
The memorial to general manager.
Correct, very correct. Now, general insurance CDA rules were formed in the year 75, 73, 76, 78.
75.
75, correct. An employee is deemed to have abandoned his post if he remains absent on
90 days.
Yes, correct.
90 days.
I'm going a little bit fast because there is one more meeting which will be coming at 1 o'clock. Okay. An employee under suspension is entitled for living allowance, dearness allowance,
Subsistence allowance.
CVC guidelines stipulate bid for acquiring office premises on lease, purchase as under technical bid, financial bid, preliminary scrutiny, or
both 1 and 2.
1 and 2, correct.
Both 1 and 2.
So you know what is technical bid and what is financial bid. Which bids will be opened first?
Technical.
Technical, and only those who qualify in technical bid, their financial bid will be opened. The CDA rules are not applicable to class 1, class 3 and 4, class 1 officer on deputation from government sector.
Class 1 officers on deputation.
Yeah, but they will be governed by their parent organization CDA. Now, Chief Technical Examiners organization function under the administrative control of CPWD, GIPSA, IRDA, CVC. Are you aware what is Chief Technical Examiner?
No.
Wherever we award any big contracts or wherever any repair or renovation work is being done, so that time, in order to ensure that the tender process has been followed properly, payment schedules has been properly followed, and examination of the structure has been done properly, there is one wing under CVC. Those officers, they will come to office and they will check into tender process, the payment procedure followed, then whether any amount has been deducted or any amount has been kept as a in case any future defects are known and all. So the Chief Technical Examiner is an organization function under CVC. Common proceeding against 2 or more employees are permissible under rule. हमने जो भी बताया था आपको 29.
Excuse me, sir.
हाँ.
Sir, excuse me, sir. पिछले का आंसर क्या था? पिछले क्वेश्चन का आंसर.
Central Vigilance Commission.
जी, okay sir. Okay sir.
Now, common proceeding against 2 or more employees are permissible under rule. That is 29. I have explained it to you. Rule number 29 and 30. Then CVC stands for what? Central Vigilance Commissioners and Chief Vigilance Commissioner, Central Vigilance Commission. Huh?
3 Central Vigilance Commission.
Central Vigilance Commission. Dismissal order can be issued by officer in charge, competent authority for imposing major penalty, appellate authority, or appointing authority.
Appointing authority.
Appointing.
Subsistence allowance can be increased to 75% after 3 months of suspension, 6 months, 9 months, or never.
6 months.
6 months.
Correct.
6 months.
During the pendency of the inquiry or proceedings, if an employee is found to be suitable for promotion, then consideration of promotion
kept in a sealed envelope.
Kept in sealed envelope.
Yes.
On noticing misconduct, what is the recourse available to disciplinary authority? Exonerate to start disciplinary
proceedings. To start disciplinary proceedings.
Yeah.
To
start disciplinary proceedings.
We identify which of the following does not attract vigilance angle: unusual delay in taking decision, reckless decision attributing to financial loss to the company, possession of disproportionate asset, failure to submit annual property returns.
Unusual delay in taking decision.
Pardon?
Or failure to submit
1.
annual property return.
1. Unusual delay in taking decision.
See, even unusual delay in taking decision will also attract a vigilance case. I will give you an example. Supposing if the claim is already settled and the person who is supposed to release the check or make the payment is still not releasing the payment, and if there is a complaint from the client that he is asking some sort of a gratification from the for early release of the claim check, then definitely that will attract the vigilance anger. If a pension opt is terminated by way of major penalty, which of the following is not payable to?
Gratuity.
Gratuity.
It will not be payable to him. And pension, see, I told you that they can go for a compassionate pension for his family members. Which of the following misconduct won't attract vigilance anger? Misappropriation of funds causing pecuniary loss to the company by wrong action, remaining
For
absent.
remaining absent 1 day.
For 1 day on CL.
Yes, can. Who can act as a defense assistant in an inquiry proceeding? Only
Any employee of the organization.
Any employee of the organization. Right. What will the fate of the inquiry proceeding if the employee dies after issue of charge sheet, after completion of the inquiry, after submission of inquiry report, after passing of his office order, but before it received by him? So here I am asking you, what will the fate of the inquiry? If the charge
Inquiry
sheet
comes
is
to end.
inquiry will comes to an end. Correct. Now, disciplinary can be initiated against retired employee under pension rule.
4 years.
4 years. Correct. Now, major penalty can be imposed on an employee against whom major penalty charge sheet is issued. It is correct. See, if a person has been issued with a major penalty, then disciplinary authority has got a right to impose a major penalty. Minor penalty can be imposed on an employee against whom minor penalty charge sheet is issued. Yes, because he has been issued minor penalty charge sheet, minor penalty can be imposed. Minor penalty can be imposed on an employee against whom major penalty charge sheet is issued. Yes. But major penalty cannot be issued for a person against whom minor penalty charge sheet is issued. Okay, why? Why major penalty cannot be issued, cannot be imposed on a person against whom minor penalty proceeding is initiated?
Because charge sheet and inquiry has to be committed.
Because he doesn't get the personal hearing or oral hearing. The authority to forfeiture for gratuity is with disciplinary authority appointing DMP, CMD or CU. It is CMD. The standard of proof required in departmental inquiry is that of proof beyond reasonable doubt. Preponderance of probability depends upon the discretion of the inquiry officer.
Beyond reasonable doubt.
No, beyond reasonable doubt is required in court. In
criminal proceedings.
But in our departmental inquiry,
preponderance of probabilities.
What is preponderance of probability? Now, supposing if a person has misused the cover note and tomorrow he comes up with a plea that this cover note has not been signed by me, so I should not be held responsible. But since the cover note book was given to him, and for that we have got a sufficient proof with us that it was handed over to him, he has acknowledged. So misuse of the cover note, the responsibility of misutilization of cover note falls on him. So based on preponderance of probabilities, he can be declared guilty. Now, terminal dues which cannot be attached by even an order of the court is PF, gratuity, leave encashment, GST. I told you, I've explained it to you.
Leave encashment?
No. I told you PF by way of any court's order, forum, or any tribunal, it cannot be attached because that is your own money, so that will go to you only, even if you have been terminated from the services of the company. Under Prevention of Corruption Act, a government servant can be prosecuted for wrongful gain, misappropriation.
All of the above.
All of the above. Correct. What procedure is followed in acquiring office premises as per CVC guidelines? Advertisement in newspaper, placing the advertisement on.
All of the above.
Yes, all of the above. Now, which is correct sequence as per CD rule? Investigation, charge sheet, domestic inquiry, order. Investigation, domestic inquiry, charge sheet, order, domestic inquiry, charge sheet, investigation, order. First, what will you do? First, there will be investigation. Based on investigation, charge sheet will be issued. Then after issue of charge sheet, domestic inquiry will be done, and based on the findings of the inquiry officer, final order will be first. So it will be first. Then, as per CDA rule, who can be appointed as inquiry officer? Public servant, only central government officer, officer of the company, retired officer.
Officer of the company.
Officer of the company and retired officer of the company. Then which of the following is not a major penalty? Termination of services, withholding of increment permanently, withholding of increment.
3. Withholding for 2 years.
Yes, correct. Now, who can act as defense assistant? Employee of the company, retired employee of the company, legal practitioner, employee of other PSU general insurance company.
Employee of the company.
Only employee. Now, section 16A deals with annual employee report. Then what is this?
Annual property return.
Property return, annual cost statement, annual property return, annual claim statement. Which is the answer?
Annual property return.
Annual property return.
Which is the correct sequence? First order of appellate authority, then of disciplinary authority. First order
2.
of disciplinary authority.
Disciplinary authority, appellate authority, memorial.
I think everyone is understanding, na?
Yes.
If a person has been detained in police justice custody exceeding 40 hours, he is deemed to have been suspended from the services. If no bail is granted to him, he could not get bail due to intervening holidays.
If no bail is granted.
If no bail is granted. Suspension can be revoked by disciplinary authority, appellate authority, CMG, the authority who has placed the said employee under suspension. Who can revoke that suspension?
The authority who has placed.
Appellate authority.
No. The person who has placed him under suspension. Here the question of appeal will not come because this is not a penalty. Now, inquiry should be ideally completed within a period 3 months from the date of appointment of the inquiry officer. 9 months.
6 months.
6 months.
6 months.
Now, an appellate authority can enhance the penalty, reduce the penalty, exonerate the employer, all of the above.
All of
See, he can enhance the penalty, he can reduce, or he can, because it will be depending upon the merit of the case. So he can do all of the above.
All of them.
Which of the following action won't be called a misconduct? Taking, giving bribe, submission of fair or false LTS bill, giving oral and state statement when placed without the permission of the office, sleeping while on duty, or occasional late attendance.
Occasional late attendance.
Fifth, sir.
Occasional.
Occasional late attendance.
Occasional.
An employee can be placed under suspension except in case of action is contemplated against him. He is detained in the police custody for more than 48 hours. Criminal case is pending against him or unauthorized absence. Except in case of.
He is detained in custody for more than 48 hours.
No, he has to.
Unauthorized force.
Action.
Why he should not be placed under suspension? Because in unauthorized absence, as it is, he is not entitled to get any salary. But if you place him under suspension, he will start getting 50% salary, for which he will be quite happy.
Okay.
Whether a suspended employee can engage himself in gainful employment, work in different office, be present in the office and do the work, he should not be allowed to do work in any of the office.
He should not be allowed to do work.
Fourth, sir.
Yeah. Disciplinary authority must give copy of the inquiry report to the employee, not necessarily give copy of the report, should give copy only if employee demands. Under no circumstances it should be given to employer. It is possible. I'll tell you any after
Should give
the
a
receipt
copy.
of after the receipt of the correct. Inquiry report has to be given to the employee to make representation against the findings of the inquiry officer. If 2 vigilance cases are going against and 1 employee, how many penalties can be imposed upon him? Not more than 1 penalty, any number of penalties, separate penalties for 2 separate cases, none of the above.
Third,
Penalties for 2 separate cases.
Separate penalties. Which of the following statement is true? Disciplinary authority himself can conduct inquiry as inquiry officer. Inquiry can be conducted by the duly appointed inquiry officer. Only first statement is correct. Only second is both the statements are incorrect and both the statements are correct. See, disciplinary authority is the one who assigns, who delegates his authority for an officer who has been appointed as inquiry officer, and he also can conduct the role of an inquiry officer. So therefore, both the statements.
Both are correct.
both the statements are true.
What happens if the employee suddenly admits the charges during the course of the inquiry? Inquiry needs to be completed. Inquiry comes to an end. Inquiry will be temporarily suspended till the advice of Vigilant Department issued IO to seek advices of disciplinary authority.
Inquiry comes to an end.
Correct. Inquiry comes to an end because there is no need to prove anything because he himself has admitted the charges unconditionally. Now, reference is made to CVC initiating disciplinary action as the senior assistant development was scale 4, scale 5 and above.
Scale 5 and above.
Scale 5 and above.
Scale 5 and above. Then an appellate authority can enhance the penalty, reduce the penalty, exonerate the employee, all of them.
All of them.
All of the.
Then in domestic inquiry, which of the following is not correct? He cannot defend his own case. He can be assisted by defense assistant from the same region. He may engage a legal practitioner. He can engage an employee from other ROS.
He may engage a legal practitioner.
He cannot be a. Do you know what is CDI? CDI means Commissioner for Departmental Inquiry, who comes under the wings of Central Vigilance Commission. Means supposing what happened now, suppose if any case is when registered against chief manager, deputy or deputy DGM or GM or for that matter CMD also. So that time now the officers from our organization, they would like to do, they don't like to be the inquiry officer in such cases. Or there is one more factor involved, that supposing if you appoint any officer from the organization, they will try to favor that employee also. Therefore, CVC has got one wing of CDI, that is Commissioner for Departmental Inquiry. Those people will be appointed as inquiry officers. Their main function is to work as an inquiry officer. So friend, because I have been given a time up to 1 o'clock, still we have got 10 minutes of time. If any query is there, because I hurried through this presentation of question answer.
Excuse me, sir. Please tell me the sequence of the procedure, inquiry or first inquiry or investigation.
Now you can note down. See, first there will be some sort of a complaint or a source information about happening of any misconduct. Okay.
Wait minute, sir. So, Hanji sir, please note. Please.
There will be a complaint. There will be a complaint.
Yes, sir.
About a misconduct.
Yes.
Then it will be investigated by Vigilance Department.
Investigation, okay.
VO. Then the report will be given to CVO.
CVO, okay.
Then he will advise in consultation with disciplinary authority.
Okay, advisor हो गया, ठीक है.
Or either major penalty or minor penalty.
सर जैसे आपने बताया था कि पहले इन्वेस्टिगेशन फिर चार्जशीट.
अरे सुनो ना, आप पहले उनने तो डिसाइड करना चाहिए ना, डिसिप्लिनरी अथॉरिटी ने.
ओके
चार्जशीट इश्यू करना है क्या?
ओके सर.
तो दे विल डिसाइड वेदर मेजर पेनल्टी करना है या माइनर पेनल्टी करना है.
जी सर.
उसके बाद में चार्जशीट इश्यू होगा.
ठीक सर.
चार्जशीट इश्यू होने के बाद में रिटर्न स्टेटमेंट ऑफ डिफेंस आएगा.
ओके, रिटर्न स्टेटमेंट आ गया, ठीक है.
रिटर्न स्टेटमेंट डिफेंस के बाद में आईओ पीओ अपॉइंटमेंट होगा.
ठीक है जी. उसके
बाद में इंक्वायरी होगा.
इंक्वायरी.
फिर इंक्वायरी के बाद में रिपोर्ट आएगा, इंक्वायरी रिपोर्ट आएगा.
रिपोर्ट आ गई, ठीक है.
बाद में इंक्वायरी रिपोर्ट चार्जशीटेड एम्प्लॉय को दिया जाएगा. इंक्वायरी रिपोर्ट पे इसका रिप्रेजेंटेशन, चार्जशीटेड एम्प्लॉय का रिप्रेजेंटेशन आएगा. Then disciplinary authority will decide what sort of penalty has to be imposed. And accordingly, office order will be passed.
Hello. Sir, I have one doubt.
Yeah.
Sir, my doubt is that
as you have rightly said, that in case of police custody of 48 hours, the person
more than 48 hours.
Exactly, sir. So now the question comes: if the criminal case is going on and the person is convicted but not sent to custody, what the position of the person is?
I'm not understanding your. See, what I understood now from what you said, a person has been kept in the custody for more than 48 hours.
Sir, if person is in the custody, he is suspended more than 48 hours. Is it clear, sir? Sir, if the custody is more than 48 hours, excluding holidays, then the person is suspended. So now my question comes: in a criminal case, the employee is convicted, but he is not sent to, he is not given a police custody. He makes an appeal. Where the person concerned, will he be suspended or not?
If he is in if he has been convicted, then straightway by invoking the provisions of rule number 30, he has to be dismissed from the services of the company.
He will have to. Thank you.
Because he has been convicted. No?
Thank you, sir.
Any question? I hope.
Hello.
Yeah.
Yes, sir. One doubt is here. If the custody is less than 48 hours, suppose it is 26 hours, what about that day? He will get salary or not?
Pardon? No, he will not be placed under suspension, but that period will be counted as if, he was not in service. No, that time. He will not get any salary for that period.
Okay.
See, his date of detention and date of release. Even if he is deemed suspended now, he will not get any sort of a salary.
Right. Okay. One more doubt, sir.
Yeah.
Sir, like the employee is penalted for 2 stages permanently, like to increment down. And he the effect of this is that he will not get promoted for next 2 years.
Yeah.
Right. And what about that period which is involved in the investigation procedure, like 2 or 3 years?
No, it is from the date of passing of the final order by the disciplinary authority.
But he will not get promotion while the proceedings are going on.
See, when the proceedings are going on, his name will be kept under sealed envelope. That I have told you. And only after the decision of the disciplinary is known, and if he has been exonerated, his envelope will be opened.
Right.
Any question?
Sir, any more MCQs can be available on pension, gratuity, medical questions, so that we can solve at the home before examining.
What do you want? You want this presentation? Now that will be shared with you.
Sir, except presentation के बिना कोई जैसे numerical questions है, जैसे पेंशन क्या कितनी मिलेगी, बेसिक पेंशन कितनी मिलेगी, फैमिली पेंशन, उसके रिगार्डिंग क्वेश्चंस वगैरह तो जो हम सॉल्व करके देख सकें घर पे.
पेंशन का आपको बताता हूँ ना मैं. पेंशन का देखो 33 इयर्स के लिए 100% पेंशन मिलता है. बाकी आपको उसका प्रोपोर्शनेटली रिड्यूस करना होगा. पेंशन का रूल है व्हाटएवर इज बेसिक योर लास्ट बेसिक सैलरी फॉर 10 months, एवरेज बेसिक सैलरी, that is to be divided by 20. 2 so that is 50% will be your basic salary, and on that whatever DA you get, that is your pension. Out of that 50%, that is basic salary, you can commit 1/3 of your pension.
जी sir.
Now supposing if your basic pension is 45,000 rupees, so 15,000 rupees you can sell, so you will get 30,000 rupees plus DA on 45,000.
Yes. Family pension is commute 1/3.
Family pension 1/3 मिलता है.
Family pension 1/3. सर जो एक 15% होता है, एक एडिशनल पेंशन क्या होता है, वो एक 15% भी होता है कुछ.
कौन सा?
Sir, I have studied in some numerical questions. जब फैमिली पेंशन में कुछ होता है 15% मिलता है पेंशन का.
आप जरा थोड़ा देखो कैसा है मैडम. अभी है ना मेरा एक्चुअली सेशन खत्म हो गया है. Some people are waiting here, so वो आपको पेंशन का देख लेना, उसमें कुछ ये नहीं.
Sir, I want numerical questions if they can be.
Numerical question ना वही मैं बोल रहा हूँ. You can go through the pension rules, उसमें आपको मिल जाएगा.
Okay sir. Okay sir. Okay sir. Thank you sir.
So friends, with this I am concluding my session. I hope You must have understood whatever subject I was trying to teach you. So what is your feedback?
Sir, very good, very excellent.
It was quite an interactive session, I believe.
Sir, we got so much.
Thank you very much. So in case,
Dr.
pardon?
Very nice session. Very nice and sir, it is very nice session.
Thank you.
Very nice and informative session.
Okay.
And we are quite happy.
See, I'll be sharing this presentation with you, and if you need any clarification assistance, you may get in touch with me on my email ID or my cell number. I'm always available.
Sir, can you share at where you can share your mail pass?
I've already given it to our this BVKS, and they will be giving it to you because you are all email ID. Telegram group. That will be shared on the Telegram group.
Okay, sir. Okay, thank you, sir.
Okay, thank you and all the best.
Okay, thank you, sir.
I wish you all the best in your examination and hope all of you will get promotion.
Thank you so much, sir. Thank you.